Good morning. We're on the record. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Code Section 2-571 et seq. Of the Open Meetings Act, OMA, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central Meeting calendar. Notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Ms. Terry Janine Quinn.
Ms. Terry Janine Quinn, present.
Mr. David Meadows.
Good morning, Mr. David Meadows, present.
Mr. Ryan Jones.
Morning, Ryan Jones, present.
The board has 4 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 9 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your cameras will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first order of business today is a protest hearing, case number 25 PRO 00038, Umbar, license number 90240. This case has been canceled due to submission of a settlement agreement for the board's review and approval. The next case on our calendar, show cause hearing status case number 25 CMP 00021, Flair Restaurant and Lounge, license number 120179. Good morning, Mr. Charles. Can you please elevate the rights of the parties in this case?
Parties have been elevated.
Good morning. Thank you, sir.
Good morning.
Good morning. Let's start with you, Mr. Lency. Can you please spell and state your name by identifying yourself for the record, sir?
Morning, Chairperson Anderson. Colin Chenci, COLLINCENCI, Assistant Attorney General with the Office of the Attorney General for the District of Columbia, representing the district today.
Good morning, sir. Mr. Ayalu, can you please spell and state your name for the record and your relationship to the establishment, sir?
Sure. My name is Bekalu Ayalu, Bekalu, last name Ayalew. I'm the owner of the establishment.
Good morning.
Morning.
Mr. Sensi, are there any preliminary matters in this case?
I just want to inform Mr. Ayalu that an offer in compromise email is forthcoming today, so it'll be sent terms today.
Good morning. All right, sorry. Here, since there are no preliminary matters in this case, this matter, if it goes to a show cause hearing, it is scheduled for September 10th at 10:30 a.m. If this matter goes to a hearing, I want to remind the parties that 7 days prior to the hearing, the parties are required to disclose documents and witnesses. And what that means, sir, if you tend to contest this hearing, if you're going to rely on documents, if you're going to rely on witnesses, you need to provide a copy of these documents and your witnesses to the government 7 days before the hearing, and you also copy ABCA legal on these documents and witnesses. And failure by either party to disclose the documents and witnesses 7 days prior to the hearing, unless reasonable cause is shown, the board is empowered to prevent that side from relying on documents and witnesses that have not been disclosed. Do you have any questions, sir? Or do you understand what I just stated?
Yes, I do. And I also wanted to ask, I mean, I'm admitting the fact that.
Well, you don't need to do
Yeah.
that right now, so you can have that conversation with the
hearing.
government.
Okay.
Yeah.
Okay.
But I just want to make sure that you understand the instructions that I just provided.
I do.
And so what the government basically stated is that they're going to send you an offer in compromise. So if what is submitted to you, if you agree to it, you can sign it, and then we won't have a hearing on it. But if you contest that, then we can go to a hearing. You can negotiate with the government. You cannot, however, negotiate with the board. So therefore,
Okay.
when if whatever offer they submit to you, if you disagree with it and you come with the board, then the board will make a decision whether or not you're guilty of the infraction, and the board will impose its own terms and conditions, which could be different from the terms and conditions that were provided to you. Okay.
All right. Thank you so
All right.
much.
All right, you're welcome, sir. So, you guys have hope if you're able to resolve this, then it will be resolved. If not, I will see you on September 10th at 10:30 a.m. All right. Have a great day. Thank you.
Yep.
All right, the next case in our calendar is case number 24 CIT 00852, Mr. Rotisserie, license number 120562. Mr. Charles, can you please elevate the rights of the licensee in this case?
Mr. Chairman, I do not see the licensee in this case.
All right, that's fine if you don't see. You can drop Mr. Alayu. You can drop him from the call, please.
Yes.
Okay. All right, Mr. Senti, can you please identify yourself for the record, sir?
Colin Chenchi, Assistant Attorney General with the Office of the Attorney General for the District of Columbia, representing the district.
Good morning, sir. I see that the licensee is not here. However, at show cause hearing status, there is no requirement for the licensee to be present. If this matter is not settled, it's then scheduled for a show cause hearing on September 10th at 10:30 a.m. Just want to remind the parties that if 7 days before the hearing, the parties are required to disclose the documents and witnesses that will be relied upon at the hearing. Failure by either side to rely on to disclose documents and witnesses 7 days prior to the hearing, the board is empowered to prevent that side from moving forward. Okay, thank you. Mr. Grant, you're on. I can hear you, sir. So you either have to come on camera or, all right. So are you available to come on camera, Mr. Grant?
In 1 second.
All right. The next case in our calendar is case number 24 CMP 00075 Flash, license number 90823. Mr. Charles, can you please elevate the rights of the licensee in this case?
Licensee has been elevated.
Thank you, sir.
Hello.
All right, good. Hold on. Hold on. Mr. Chenchi, can you please identify yourself for the record, sir?
Chenchi, Assistant Attorney General with the Office of the Attorney General for the District of Columbia, representing the district.
Good morning. Mr. Matagehai, can you please spell and state your name for the record, sir?
Afshin Matahi, AFSHIN, last name MOTTAGHI.
Can you pronounce that one more time for me, sir? You have appeared in front of me sufficient times that I should know, but do it one more time for me, please, sir.
It's Afshin Matahi.
Mr. Matahi. All right,
Yep.
Good morning, sir. Mr. Chenchi, are there any preliminary matters in this case?
Nothing from the district.
Any preliminary matters you want to raise, sir?
No.
Okay. All right. This matter then is scheduled for a show cause hearing on September 10th at 10:30 a.m. Just want to remind the parties, if this matter actually goes to a show cause hearing, you are required to file documents and witnesses you will rely upon at the hearing 7 days prior to the hearing. Failure by either side to disclose documents and witnesses they will rely upon at the hearing, the board is empowered to prevent that side from relying on documents, on documents and or witnesses that have not been disclosed. And so the documents should be submitted to the government, and also a copy of the document should also be provided to ABCA Legal. Okay, any questions?
No.
All right, have a good day. Thank you very much.
Thank you.
All right, I just want the record to reflect that Mr. Silas Grant has now joined us. The board now has 5 members to participate in our hearings today. And we do have a quorum, because a quorum for the ABC board is 3 members. All right, the next case in our calendar is case number 25 CMP 00038, Elephant and Castle Pub Restaurant, license number 89845. Mr. Tenchi, can you please, I'm sorry, Mr. Mr. Charles, can you please elevate the rights of the parties in this case?
Parties have been elevated.
Thank you, sir.
Mr. Chair, I believe there might be one more person from Elephant and Castle, Sarah Sutherland.
Is Mr. Charles, do you see a Miss Sutherland? Mr. Charles, you see a Miss Sutherland waiting to be elevated?
Yes, Mr. Chairman, here she is.
Thank you, sir. Thank you, Mr. Miss Sutherland, are you able to come on camera, ma'am? All right, good morning, everyone. Mr. Tenchi, can you please identify yourself for the record?
Alan Chenchi, Assistant Attorney General with the Office of the Attorney General for the District of Columbia, representing the district.
Good morning. Miss Sutherland, can you please spell and state your name and identify your representation this morning, ma'am?
Sarah R. Sutherland, Head of People and U.S. Business Operations for Elephant and Castle, spelling of last name Sutherland.
Mr. Doak, can you please spell and state your name for the record and your relationship?
Derek Doak, President of Elephant and Castle US, ABCA, last name D-O-K-E.
Good morning. Mr. Tenchi, are there any preliminary matters in this case?
Mr. Chair, just want to inform the board that an offer in compromise should be forthcoming, hopefully by the end of this week.
Thank you. All right, if this matter is not settled, it is then scheduled for a show cause hearing on September 10th at 10:30 a.m. And what this means, and so therefore, if this matter actually goes to a hearing, the parties are required to disclose documents and witnesses they will rely upon at the hearing 7 days prior to the hearing. Failure by either side to disclose documents and witnesses 7 days prior to the hearing, and those documents should be sent to the government, should send its documents to the licensee, and a copy of those documents should be sent to ABCA Legal, and the licensee should do the same also. So failure by either side to provide documents and witnesses 7 days prior to the hearing, the board is empowered to prevent that side from relying on documents and witnesses that have not been previously disclosed. Any questions by anyone?
No.
The district.
All right, so if the matter is not settled, then I will see you then on September 10th at 10:30 a.m. Have a great day. Thank you. All right, the next case in our calendar is case number 25 ULC 00057, the Garden DC. And this is, I believe that a hearing was requested. So, Mr. Charles, can you elevate the other parties in this case? I think there should be a Mr. Richard Bianca, and I'm not sure if there's anyone else who is in the waiting room to be elevated for this case.
All available parties have been elevated.
Thank you. Good morning. Can everyone please come on camera? All right. Good morning, everyone. So let's start off with the government. This is actually a status hearing, I believe, that was requested by the agency. But I'll have let the parties identify themselves for the record, and I'll start with the government.
Good morning, Mr. Chair. Colin Chenchi, COLLINCENCI, Assistant Attorney General with the Office of the Attorney General for the District of Columbia, representing the district today.
Good morning. Mr. Bianco, please identify yourself for the record, and who do you represent?
Sure. My name is Richard Bianco, RICHARD BIANCO. I represent the second intervener. It's an LLC called 1535 NJA LLC. It is the current owner of the premises. And with me, I have the principal of the ownership entity, Sunny Preet.
So do we have Sunny Preet? Can you please identify yourself for the record by spelling and stating your name? Sir, you're on mute, so I can't hear you. I still can't hear you, sir. So either turn your volume up or you are on mute, so I don't know why I'm not hearing you. I still can't hear you, sir. Well,
1 second, I'm trying to.
I can hear you now, sir. So just spell your spell and state your name for the record and who you think, sir.
Okay, first name SONNY, last name PREET. I am the managing member for 1535 NJA LLC, the property owner.
All right, thank you. I'm going to ask everyone, if you're not speaking, I'm asking everyone to mute their lines unless they are speaking. All right, Mr. Zoe, can you please spell and state your name for the record, and who is it that you represent, sir?
Good morning, Mr. Chair. My name is Yutong Zhou, YUTONGZHOU. I'm here on behalf of the establishment Garden LLC.
I'm sorry, who is it that you represent, sir?
The garden, the establishment.
All right, so Mr. Wardi, can you please spell and state your name for the record?
Hamza Wardiri, HAMZA, last name Wardiri, WARDERE. I am representing the landlord, Shami LLC, SHAMI LLC.
So you're representing the landlord. And what establishment is this? I'm sorry, what's the name of the entity, sir?
Shami LLC, SHAMI LLC.
Okay. And I think we have Miss Ellern Feldman. Can you please spell and state your name and who it is? Mr. Zoe, can you please mute your line, sir? Can you, Miss Ellern Feldman, can you please spell and state your name for the record and who is it that you represent, ma'am?
Good morning, Lisa Ellern Feldman. Last name is ELLERN-FELD as in dog, MAN. I represent the former owner of the premises, the estate of Dolores Satterwhite. The property has been sold.
So if, okay. All right. All right. I guess okay. This case basically started out that there was an offer in compromise regarding because there was an unlicensed establishment, and an offer in compromise was signed between the government, the licensee, and the landlord. And apparently there was some dispute exactly who the landlord was, and so the government had failed to decided that they were going to move forward with the offer in compromise. So maybe the government can just clarify from the government's perspective, where was the government with this offer in compromise, and then why is it that the government had decided not to move forward with the offer in compromise, and then I'll have the other party, the parties, then explain to me what's going on.
Yes, Mr. Chair, just as a way of brief background on this case, as you correctly stated, we were prepared to move forward with offers in compromise for both the establishment, the Garden LLC, which was to leave the premises, and with, at the time, our understanding of who the landlord was. Our understanding at the time was James Satterwhite. That information was incorrect. It was actually owned at the time of the estate of Dolores Satterwhite, who had passed away prior to the initiation of this proceeding. However, based on representations that we received from the establishment, we were told that the landlord had a business manager / representative in Hamza. Based on that representation from counsel at bar, the district proceeded forward with preparing a landlord offer in compromise to be signed by Mr. Wardiri on behalf of James Satterwhite. Prior to the board's consideration of that offer in compromise, the district became aware. I'm sorry, whoever has their microphone enabled, can they please disable it, because I'm getting an echo and it's making it difficult for me to relay the information. All right, thank you. Prior to the board's consideration of that offer in compromise, the district became aware of Ms. Alern Feldman, who was the person representative for the estate of Dolores Satterwhite, who informed the district that, in fact, the person who had signed the offer in compromise, Mr. Wardiri, was not, in fact, the landlord or owner of the property. Therefore, essentially, the district asked for the board to put a pause on that proceeding. And while the establishment's offer in compromise could be considered and was approved by the board, the landlord offer in compromise needed to be sorted out. My understanding from the filings made by Mr. Bianco is that now successfully the ongoing other disputes about who is the actual landlord and owner of the property has now been resolved. Mr. Bianco's client, Mr. Preet, should now be the owner, and the district is prepared to move forward with an offer in compromise Mr. Preet, given that he is the new owner of the property. Our understanding is that while Mr. Wardiri and Shami LLC have held themselves out as being the landlord, that information is incorrect. And given that this action was filed against Mr. James Satterwhite, who being the owner of the property, this case essentially now at no point has been against Shami LLC, has at no point been against Mr. Wardiri. Mr. Wardiri essentially has not moved to intervene in this case in any way, and so the board can safely move forward as Shami LLC is not a proper party to this action. I will defer to the other parties if Mr. Joe has representations on what Mr. Wardiri has said to him to represent his relationship with the landlord, if Ms. Lauren Feldman or Mr. Bianco have representations about the ongoing separate action involving the sale of the property to Mr. Preet. But that is the information the district is aware of.
All right, so I think that I'll start off with Mr. Bianco, and so Mr. Bianco, who is it that you represent? And
So-
yeah, and Yeah, just explain to me who you represent and how that came about.
Absolutely, and there is a lot going on here. This is more convoluted than the typical case that comes up on an OIC, so I'll do my best to be brief and accurate. So I represent 1535 NJA LLC, and that entity currently owns the property. They purchased the property from the estate of Dolores Satterwhite on or about July 9th of 2025. And I think Mr. Chenchi's recitation as to our position is accurate. The offer and compromise with the establishment, Garden LLC, which is the party that was accused and has admitted to unlicensed sales, has been already approved by the board. And at the same time, Mr. Wardiri entered into an offer and compromise, holding himself out to be the owner of the property, which he and Chamois LLC clearly are not. And in our filings, really what we're asking for is three things. One, we're asking for intervention as a party, and I think that's appropriate given the fairly liberal standard that the board has for a party in interest. And then 2 and 3 are related, which is denial of the OIC that's on the table as to Chamois LLC and dismissal of Chamois from the case. And our argument on that point, I don't think there are any factual disputes on our argument, and the distinction that we draw is slightly more narrow. I think the parties have been casually using the term landlord, and we approach it using the statutory language of commercial property owner. So the statute that gives the board jurisdiction over unlicensed sales permits the board to shut down any establishments that selling without a license or the party that is actually committing the sales, and 2, take action against the commercial property owner. In this case, Chamois LLC has truthfully represented, we believe, that they are neither the party that was making the unlicensed sales at the 1541 property, nor are they the commercial property owner. They've claimed in the one filing that I've seen to be a sub-landlord of Garden LLC. So I believe their theory is, and they haven't presented a lease or anything else to the board to my knowledge, is that in 2018 they entered into a subleasing agreement with Dolores Satterwhite, and then subleased the property to the Garden. And assuming that's true, and I really can't say if it is, but even accepting their representations as true, they are neither the party that was conducting the unlicensed sales, nor are they the party that owns the commercial premises or at any point ever owned the commercial premises. They weren't named as initially as a party to this action back in January when it originated, and they have not moved to intervene in the action. So our position is that they're not properly before the board under any theory, and that their offer and compromise should not be considered by the board. They should be dismissed from the case, which would clear the way for the government to enter into the OIC with the owner as the commercial property owner, as the statute contemplates. So our view of this is it's jurisdictional and it's pretty straightforward in terms of how the case should proceed from here. I've had discussions with Ms. Feldman and Mr. Chenchi leading up to the hearing, and I think Ms. Feldman certainly has more context on all of the back and forth that occurred between May and now, but I think her presence here as the court-appointed personal representative of the estate is important because the estate owned the property at the time of the infraction. So I think having her here is appropriate, although going forward, I don't think that the government has any interest in entering into an OIC with the former property owner, but is rather interested in the current property owners contractual commitments as to how the building will be operated on a moving forward basis. And there was a civil action that was pending up until Thursday of last week, in which Mr. Preet was plaintiff in the matter, attempting to compel the estate to sell the property to him pursuant to a contract that was entered into back in 2024. And we filed a supplemental motion, or a supplement to our earlier motion with the board, providing the Superior Court order dismissing that civil action. And as of the last time I checked last night, there were no new civil actions filed with respect to the ownership of the commercial premises. So as we sit here today, my understanding is that my client, 1535 NJA, is the sole and uncontested owner of the property.
All right, so let me ask, so who currently has custody and control of the property?
The board, or the agency. It's been padlocked since January.
I know it's been padlocked, but it's been padlocked since January. We're now in July. Who has custody? The board has the keys.
Correct.
Okay, the board has the keys, so therefore, but who has but the board doesn't own the property.
Correct. So
Who has custody? Who has custody of this property?
The leaseholder.
So the
hold on, Mr. Wardy. I'm gonna come back to you. Well, I need to speak to your attorney first. So I'm going to speak to you through your attorney, unless your attorney.
He's not my attorney. He represents the garden.
Hold on. All right. Okay.
So.
Hold on. I apologize. Then okay. So, Mr. All right. Okay. Hold on. All right. Hold on a minute. All right. Okay.
The owner has custody and control of the property.
And who's the owner?
The owner is 1535 NJA LLC. The property was in the possession of the garden. It was closed, and then as part of their OIC, the first or second paragraph of the OIC is a representation that they have vacated the property. So the garden is no longer in the picture. And upon acceptance of the OIC, the key must be turned over to the owner of the property, 1535. We've presented the unchallenged deed. I understand that Chami wants to raise some civil claim about possession, but if that's their contention, they should raise that in a forum where it can be decided, which would be the Superior Court.
All right. So let me ask a question. All right. So if we were to take, say if the board was to, since the board has the keys, the agency has the keys. So if the agency was to take the keys off, return the keys, who is it that the agency would return the keys to? I'm asking Mr. Bianco. I'm going to come to you, Mr. Wardy.
The owner of the property, which is the only party appropriately before the board. So we're the only party that the board can recognize in this proceeding jurisdictionally.
All right, Mr. Wardy, you said that you're the leaseholder. So tell me who are you? Explain to me, sir, your connection to this property.
All right. Good morning. So my name is Hamza. I represent Chami. And Chami LLC holds the lease to the building. Chami has held the lease since 2018. Contrary to what?
And who did you sign a lease with, sir?
To Mrs. Dolores.
Okay, so you signed a lease.
This is in 2018, signed the lease, and in 2024, we have signed an amendment to the lease that takes the lease all the way to 2030. Chami has held this lease since 2018. We have the valid, lawful possession for years. There's no dispute about that. The lawyer that just spoke now said that I am a subtenant of an owner, which is false. I have the direct lease, and I've been holding a leaseholder to this business for a long time. The lease has been, the building was subleased to the garden as a tenant. my right as a leaseholder is to sublease to anyone that I want. Sublease to the garden. Back in January, we terminated their lease, and we have tried to sublease the location to another business, but the business has been still in lock. Under DC law, a valid lease survives any ownership or sale. So I don't understand why we're disputing any ownership here on this forum. Just like the lawyer mentioned, if they want to take that to a proper forum, they can go to civil case. It's not my job to go to landlord and tenant to actual possession. So the question you're asking, who gets the key? Technically speaking, Shami LLC is the controlling, is the leaseholder, is the valid leaseholder of the building. So just want to be clear that if there's a landlord and tenant issue, that should be a landlord and tenant issue. But the garden has been removed. I, as the landlord, have signed the offer and compromise, and that's my rightful part to do that. I've spoken with counsel, Mr. Collin, back in May, and sent the form. So I was part of the process. I'm not sure why it said that I've never intervened or said anything in this matter. And the belief that this deed was signed in July 9th, I mean, we've spoken to the trustee and owner of this building, actually. That is in dispute. Maybe this morning, circuit court doesn't have anything, but the ownership is in dispute in probate court and civil court. And when that's decided, we'll figure that out. But what we're talking about here today is who is the leaseholder? I am the leaseholder to this place, and I've had a lease, and I will send you the lease if I need to ABCA for you guys to review. But I have no position to be talking to anyone that claims that they're owners. I've heard that different people own and control this building for the last 2 years, so this is nothing new here. But all I know is that we have a valid lease prior to any of these new owners or personal representatives that are in this case today. And whatever change that happens in this place, the lease survives, part of DC law. So if you want to give a copy of the key, maybe 2 copies to the owner and 1 copy to the tenant, I'm all for that. But to use this forum to evict a tenant or to terminate a lease is not appropriate.
But let me ask you a question. So, who is it that you said that you signed your lease with, sir?
First, it was signed with Dolores. She passed away in 2020, and the amendment was signed by Mrs. Susan Taylor, the personal representative at the time.
All right.
And trustee of the building.
All right. So, Miss Ellern Feldman, maybe you can provide some.
Sure.
Explain to me, how did you get in this case, and
Sure.
and who are you, and who did you represent, ma'am?
I was court appointed by Judge Christian in the probate division. I was appointed as personal representative. Susan Taylor was removed for cause by the probate division. So I was appointed in April. Mr. Bianco, I believe it was, I was appointed as special administrator actually in February of 2025, and then I was clearly, due to the activities actually at this property, Susan Taylor, she was completely removed, and I was appointed as personal representative in April 2025. I have repeatedly asked for documents, never received anything showing that there is any valid current lease on this property. I've asked for it many times. From Miss Taylor, from a former attorney, Don Temple, from Mr. Wadiri. I've never received any proper documents. And in fact, I have formally canceled any leases because due to not seeing anything. And so I sold the property. I'm really only here just to withdraw my motion to stay and my intervention position here because I'm no longer the owner of the property, and Sunny Preet is, and Mr. Bianco, and I just wanted to confirm everything that Richard Bianco is here saying.
All right.
Do you need any other information?
I mean, I guess you're saying that, ma'am, your purpose here is that you want to withdraw.
Correct.
Is there any objection to her withdrawal?
Yes.
I'm sorry.
Yes, I just wanted to confirm those dates that she was appointed April 2025. That's all.
All right. So, Ms. Lauren Feldman, you're dismissed from this case. I mean, without objection. Then no one is object to your withdrawal. Thank you for being here today, ma'am. So you don't need to be here for the rest of it.
May I be heard briefly, Mr.
Yeah, go ahead, Mr. Yeah, go ahead, sir.
The district doesn't object to Ms. Lauren Feldman's withdrawal. I do think it is helpful for her to be present. As I see the board already has questions, I believe questions may continue to arise about.
But I guess she's a previous. I think the bottom line, and I don't know. I don't know landlord tenant law, so I'm not going to be. So I'm going to make. But she was appointed by the court to represent an entity, and the entity sold the property to a new entity. So I don't understand why she's either a party anymore, because she has moved on. She's not involved in this case anymore. I mean, whether or not there is a valid lease, I mean, and someone can tell me if I'm wrong, whether or not there's a valid lease, I don't know. When a property is sold, I do not do landlord tenant, I don't understand what it is, because as an attorney, I'm assuming that if a property is sold, then it is sold with folks knowing that there is a tenant, and does the lease survive the transfer of the property? I don't know, but that's not a decision for this board to make. I mean, we don't get involved in disputes between landlord and tenant. I mean, if when we have OICs, we try to do the owner of the establishment to make sure that there's someone who we know has ownership, who has custody and control, in the sense that they have the keys. Because a landlord owner can evict a tenant by going through whatever proceedings, and so this is.
Yeah. I mean,
so, who's speaking? I'm sorry, we have a court reporter, so if you're going to speak, you need to identify yourself.
Hamza speaking, and you are correct. What I'm saying is that the lease survives any sale, even though the sale is disputed, and there's an authority for a personal representative to be selling the property. But that's besides the point. What I was saying is that,
But I'm
since
saying,
the
but we
lease,
don't get involved. Hold on,
yeah,
the board, we don't get involved in that issue.
and I
That's not a
agree with
board
you.
issue.
Yeah, and I agree with you. So the person that has the key and controls the place is Shandy LLC, and they have the lease. We've had this lease since 2018. I'm more than happy to provide a lease to ABCA, and that is the standing here. Other than that, I am the one that's making sure that I'm not subleasing to anyone that is unlicensed, and I'm making sure that Garden does not come back to this place, and I make sure that no one else has the right to lease this place currently to anyone else anyways, besides the leaseholder. So what I'm asking is that this board does not make a determination on who should be getting evicted and who should be staying in this place. It is not the forum for it.
So
hold on, Mr. Who wants to speak?
This is Richard Bianco. No, Mr. Preet's not going to speak.
Yeah, I was just about to say,
that's
Mr. Preet,
not happening. Yeah.
Hold on, Mr. Bianco. Mr. Preet, you have an attorney, okay, and I'm an attorney, and so you can only speak if you're for your own protection, sir. I'm saying it this way, for your own protection, because you have an attorney. The attorney speaks for you unless you tell me that he no longer represents you. Then you can speak for yourself, or if Mr. Bianco states that you can speak. So I just want to make it clear. So when folks appear in front of us, and if they have an attorney, they have now told us that the attorney speaks for them, and unless you have clarified to the board that this person doesn't speak for you, then I cannot allow you to speak unless your attorney states that you can speak, sir. Okay?
Got it. Yes, sir. Thank you.
So,
all right. Yes,
so
Mr.
I would say a couple of things. We're not asking the board to evict anyone, and we agree with the notion that the board should not be deciding landlord and tenant issues or issues of possession. And I think there's two really important concepts, factual and legal here. And that's number one is Mr. Wardiri is is here saying, no, 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 Shammy's the tenant, believe me, give me the key. He hasn't filed a single thing. He hasn't filed any representations indicating his tenancy. He hasn't filed the lease. He hasn't filed an extension to the lease. And that's not just with the board. As we heard from Ms. Alern Feldman, he hasn't provided anything to the court-appointed special administrator and then personal representative that this lease that he is claiming exists. So that's, I suppose, factual element number one. What lease is he talking about? The board has nothing in front of him. Number two, and I think more importantly, and what I think is dispositive, is the board's jurisdiction over parties is statutorily limited. The board's jurisdiction in unlicensed sales is over the party making the sale and the owner of the property. And Mr. Wardiri and Shammy LLC are neither, by their own admission. There's no dispute as to that. It's simply the jurisdiction to give them the key or to make them a party or to accept any agreement from them under an offer in compromise. Statutorily, it just doesn't exist. So they really don't have any business before the board making representations, and they in fact have not made any other than showing up here today and saying, I'm the commercial tenant / sub landlord, give me the key. And we're not asking the board to evict him. We're asking the board to make a jurisdictional determination and to turn the key over to the undisputed owner of the property. And again, the board has nothing before it. No court has anything before it indicating that anyone other than 1535 NJA is the owner. And once the key is turned over, if Mr. Wardiri or Shammy LLC or anyone else in the world wants to claim that they have some type of tenancy or possessory interest in the property, they are free to do that. But it's not appropriate for this board to make that determination. I think, as Mr. Chair, you have already stated on the record.
All right, well, but we're not even there because
Yeah.
the property is closed as far as the landlord is concerned. As far as the government, I'm sorry, as far as the agency is concerned, there's no offer in compromise. So the property will remain closed until we will maintain the keys until there is an agreement between the government and the other entity. Before Mr. Zoe, who do you represent, Mr. Zoe?
I'm here for the garden, the establishment.
But you signed an offer in compromise to state what? The garden signed an offer in compromise which has been accepted by the board that says what, Mr. Zoe?
We'll leave the premises. In fact, we already vacated the premises.
All right, so why are you here?
I wasn't excused by Mr. Berman or anybody else. So I don't think I need to be here either, to be honest.
Right, so because you signed an offer in compromise, it was accepted. Mr. Sensi, let me, did the board accept, and was there an offer in compromise assigned between the government and the garden that was accepted by the board?
There was, Mr. Chair, and it was accepted. I can just double check the date for you.
I think it was accepted by order on 6/4/25. Sorry, I didn't mean to interrupt.
No, that's all right. You have it more on hand than I do, then yes.
All right, so an offer and a compromise was signed and accepted by the board. Sir, Mr. Zoe, you're excused because you're no longer a party to this matter. That portion of this case has been taken care of. Thank you for being here today. Have a great.
Right.
Hold on 1 minute. Hold on. Let me see. Hold on. All right. All right. So are you then? I don't see you being a party to this matter anymore. Are you asking formally for you to be excused, sir, since you're no longer an active party in this litigation?
Yes, Mr. Chair, I asked to be excused.
Okay, so the garden has been dismissed because they are not a party based on their signing of the offer and compromise that was accepted by the board. Thank you for being here today. Sir, you're free to go. Thank you.
Have a good one.
May I be heard before Mr. Joe has left? Mr. Chair, I thought it would be helpful to have Mr. Joe present again for informational purposes, because again, this is how we got here into this situation, is that
well, yeah, but
we became aware. I just, if the board is not concerned about it, then that's fine. I just wanted to tell you that the district's position is that we only came to the information that Mr. Wardiri had any relationship to this establishment based on representations that Mr. Wardiri made to Mr. Joe and then Mr. Joe made to us.
Well,
That's how
I
we
think Mr. Joe can leave because he signed an offer in compromise that was accepted by the board. So there's no, as far as the garden is concerned, there is no active controversy there. They've settled their case. They can move on. The rest of it, so he's excused. So I mean, I hear you, sir, but I guess at this juncture, the garden is not a party to this litigation because
I agree, Mr.
yeah, the garden is not a part of this litigation. This litigation is about who the owner of the establishment is, and I guess the bottom line is Mr. Wardiri is saying that, Mr. Wardiri, are you still there, sir?
Yes, I am, sir.
All right, you're not stating that you're the owner of this establishment. Is that correct, sir? You're not the owner of the establishment. Is that correct, sir?
Correct. I'm saying I'm the landlord.
That's fine. Okay. All right. All right. So what is it that? So there's the building, the ABCA still maintain the keys. Is anyone asking us to remove the padlock? Is there? But you're
on acceptance of an offer in compromise with the new owner, that would be our request. It hasn't been tendered or accepted yet, but we think upon acceptance of an OIC with the owner, at that point, the padlock should be removed and keys turned over to the owner.
Mr.
The offer in compromise says landlord, right? I'm the landlord. The current owner or previous owner was never a landlord to the garden. I don't see why would they need that. And I agree with Mr. Bianco. Sorry. I agree with Mr. Bianco, but I agree with him in a different way. The board should hand the key to the landlord. I'm more than happy to provide the lease and documentations to the board. And you can give a copy to the supposedly new owner if they are willing to go to civil court and evict Shammy. They can more than happy to do that. But the board should not be signing agreements with someone that just got a quick claim deed 2 weeks ago and just hand them the keys over and effectively terminate my lease. They don't have the authority to do that.
So just on a factual point, the offer in compromise, which is attached to our motion to intervene, very clearly states, as would be proper in terms of the statutory language, the District of Columbia jointly with the quote property owner, Hamza Wardiri.
No, just continue reading. It says property owner, landlord.
Hold on, Mr. Wardiri. Hold on.
So
hold on, Mr. Bianco. All right. We have a court reporter who's keeping track of everything. So I can only have one person speaking. And when you speak, you need to identify yourself for the record. So I can't have two people speaking over each other. Mr. Bianco, you have the floor. Mr. Wardiri, you will get an opportunity once he's done to speak. Okay?
So the OIC very clearly states in the first line that the District of Columbia jointly with the property owner, Hamza Wardiri, it then defines Hamza Wardiri property owner as landlord and refers to him as landlord throughout. But the identification of property owner is statutorily very significant. It is the only party that the board has the ability to enter into an offer to cite for owning a building in which an unlicensed sale occurs, and to enter into an offer in compromise. So whether someone is a property manager, whether somebody is a sub-landlord, regardless of their status, they're not the property owner and not appropriately before the board in this matter. So our argument is really jurisdictional. And what we're asking for is the board pursuant to the statutory jurisdictional authority accept an offer in compromise from the commercial property owner and not someone claiming, without documentation, mind you, the status of a sub landlord. We're asking that the keys be turned over to the property owner per the statute, and not somebody who comes in claiming some type of sub landlord or master landlord rights to the building. And the statute's relatively new. We get it. There's not a lot of interpretive case law out there, but deferring to the plain language of it, as cited in our motions, we think it's a pretty easy analysis.
Yeah. So Hamza
Yes, Mr.
speaking.
Warderi, go ahead.
Mr. Bianco keeps using things like master landlord, sub landlord, property manager. I want to make sure that we're just being focused here. There is no laws for these terms that he's using. I am a landlord and a leaseholder. Those are proper terms that we're going to continue using moving forward, so we understand where we're at. I'm not a master landlord. I am not a property manager or some type of subtenant or any of that stuff. I am the landlord and I am the leaseholder. If the language needs to be edited to mention the offering compromises with the landlord, I'm not going to disagree with that. The document does refer to Shami as the landlord throughout. And that is exactly my position. Again, I don't just send documents to anybody that asks for documents. I still don't believe from the true owner that we've been working with in this building that the trustee controls this building and not a PR. And there isn't any authority and there isn't any civil landlord tenant cases that arise for me to be submitting a lease. And ABCA has never asked me to submit anything. There's never been disputed that the garden signed a lease with anyone else but Shami LLC since their existence in 2019, when they received the lease. So there is no reason for me to intervene or submit documents to prove anything when it's undisputed. The garden does not have a lease with any former owner or anybody. So if the board wants to refer to me as landlord and continue with this offer and compromise like we've discussed, but I don't think that this place should be blocked for 7 months while depriving us of or enjoying our rightful leasehold. That's all I'm saying.
All right. Miss Ellen Feldman, is it something you need to say, or?
Yeah, I've stayed on just to make it, just to clarify a few things that the property was never deeded to any other entity but the estate, right? And the estate properly transferred the property to the new owner in July. And so any other representations is just incorrect. There's no, I think Mr. Wadiri is saying a bunch of things that are trying to obfuscate the facts. So I'm here to I stayed on to clarify what the facts are. The facts are is that the estate always owned the property. The estate properly sold the property in July to the new owner. The new owner is properly before the board under the statute as Mr. Bianco has represented. So I hope that's helpful.
Mr. Tenchi, as far as the government is concerned, what does the statute states who we sign when offers and compromise are signed? Who is it that offers and compromise are signed with?
Mr. Anderson, the motion that Mr. Bianco filed accurately cites the law. DC Code 7/1675.01 contemplates penalties for the commercial property owners. Does not say landlord, says commercial property owner. And also citing back to 7-1671.08 G3, similar situation with that language. ABCA shall provide the unlicensed establishment's owner, Mr. Joe and the Garden LLC, and the property owner, this point, Mr. Preet, with written notice of the summary closure and the right to request a hearing. It does not contemplate this middle step of a intermediate tenant who is the sub-landlord for the commercial, for the establishment itself. It contemplates the property owner and it contemplates the establishment. And where Mr. Wardiri is making representations that, well, because the offer and compromise says landlord as an abbreviation to refer to a party throughout a document, that's not what the document is saying. The document is saying property owner because it tracks with the statutory language. Just because the district chose to use an abbreviation does not automatically bind the district to something that doesn't exist in the law.
All right, Mr. Warderi, the statute says property owner. Let me ask, I'm asking you a specific question, sir. Are you the property owner?
No.
All right, thank you. All right. Okay. All right. So is Mr. Bianco, is it that your client, do they wish, or is it their intent that they want to enter into an offer in compromise with the government?
They do, and I've spoken with Mr. Cenci about it, and my client, and they are willing to enter into an offer in compromise on the same terms as the originally submitted offer in compromise that Shammy had put forward. We haven't written it yet. I think we wanted to see the outcome of today's hearing, but for the board's knowledge, the terms will be identical.
Is there any other issues that the parties wish to address today?
In the district.
None from the intervener.
So,
Warderi, I guess you want to say something, sir?
yeah, so essentially you're giving them the key and evicting the leaseholder with doing this.
Mr. Warderi, the board is not doing anything because there's no.
So I want to understand what that is, the offer in compromise,
I'm saying that nothing has been provided. No one is getting the keys to this property today. Okay, the only way keys will be returned is if an offer in compromise has been agreed to between the property owner and the government. That is, and then the offer in compromise is then provided to the board, and the board will vote on the offer in compromise. And I think typically an offer in compromise states that the owner will ensure that the property is not rented again to an unlicensed establishment, and that it will basically state that the landlord would have to, or the owner would have to let the board know of the board and the government aware of the new owner. And so as long as we are aware that the new tenant, whoever the tenant is, that as long as if they're going to sell cannabis, that they have to have a license. If they don't have a license, then they can't. And so that's what the offer in compromise. The offer in compromise doesn't say who the tenant is going to be. It just says that before we will return the keys, you, the owner, have to assure us that all the cannabis will be removed, the unlicensed establishment will be there, and if you're going to bring in whoever the new tenant is, they cannot sell cannabis without having a license. It won't talk about so that's if an offer in compromise is accepted, that's going to be the term. It's not going to state who the tenant is, and so it's not going to be that the board is evicting you, or the board would not be making a decision on whether or not you have a valid lease. That's not our decision. You have stated on the record today that you are not the owner of the establishment, and from the law states that the offer in compromise is signed between the owner.
Okay.
All the other issues are issues that needs to be whether or not if you say that you have a lease, then and if it survives the sale, that is for another forum. That's not for the board.
Correct.
So all right. So
Thanks for clarifying.
Thank you. So the board, we're going to take this matter under advisement, and we're going to issue we'll issue an order on the decision that we'll make. But the gardener was dismissed because they're no longer a party. Ms. Alern Feldman, thank you for being here today. You're not a party, and if there's any further hearings on this matter, there's no requirement for you to be here, ma'am, unless someone decides to call you as a witness. But you are not a party, and you're not a party. You don't have any party interest in continuing litigation, if there is any, regarding this matter. Okay, ma'am. So thank you for being here. And with that said, the board will take this matter under advisement, and we will issue a decision. And Mr. Warderi, where we are, the property will remain padlocked until and unless an offer and compromise has been provided to the board for its review and consideration, and based on the terms of the offer and compromise, then it will determine whether or not the locks will be removed. And you and the owner need to figure out whether or not you have a lease and what that lease states if the property is sold. Okay.
Thank you.
All right. All right. Any other comments before I close this hearing? All right.
No,
Thank everyone for being here today. Have a great day.
Thank you, Mr. Chair.
All right, you're welcome. All right. All right. All right, the next case in our calendar is case number 24 CIT 00828, Kitchen and Cocktails by Kevin Kelly, DC, license number 123472. Mr. Charles, can you elevate the rights of the parties in this case?
Mr. Chair, I see just one party in this case, and they have been elevated.
All right, can you put on in the chat to say if there's anyone here for Kitchen and Cocktails? Could they identify themselves for the record? Just put that in the chat for me, please, sir. Hold on 1 minute, please.
I have placed that in the chat. I'm just waiting to see if there are any responses. No responses?
Okay, I'm back. All right, that's fine. All right. Okay, so Mr. Tenchi, can you identify yourself for the record, please?
Yes, Mr. Chair. Colin Chenchi, COLLINCENCI, Assistant Attorney General of the Office of the Attorney General for the District of Columbia, representing the district.
Good morning, sir. I see that the licensee is not here today. Is the government prepared to move forward?
Mr. Chair, I just asked for a brief pass on this matter. I'm status attorney. I just want to confirm.
Oh, I'm sorry. Okay, I thought this was your case.
No, it's not, with the assigned attorney. I was here for everything else, just not this one.
Mr. So who's Mr. Charles? Let me see. This case is Mr. Coughlin, Coughlin. So is Mr. Charles? Is he waiting to be elevated?
No, I do not see him in the chat. There is one call-in user.
The government will not be a call-in user. So let's be off the record for. It's 11:41. We'll be off the record until 11:50. We're off the record until 11:50, and then we'll find out who's representing the government in this case. Okay, so we're off the record until 11:50.
Thank you, Mr. Chair.
Yeah, thanks. We're back on the record. I know this is not your case, Mr. Chinti. Do we know? Okay, there is the government's attorney. There's a.
Just wanted to make sure he was on before I left. Nice
Thank
to meet
you. Yes, sir. Thank you. Have a great day.
You too.
All right, so this is case number 24 CIT 00828, Kitchen and Cocktails by Kevin Kelly, DC license number 123472. Will the parties identify themselves for the record, starting with the government? You're unmute, sir. Can you unmute yourself and identify yourself for the record? Mr. Coughlin, can you hear me, sir? I need you to unmute yourself, sir, and identify yourself for the record. Can you guys hear me?
Yes, Chairman, we can hear you.
Thank you. Well, you need Mr. Charles, can you Yes, Miss Graham? I can't hear you, Miss Graham.
Are you able to hear me?
Yes, ma'am, I can tell you. Can someone tell him to use some headphones, because I can't maybe he can find some headphones so he can hear us. But he needs to unmute himself. Mr. Charles, can you send him a link for him to unmute himself?
Yes, I'm contacting him now.
Thank you. You can put your hand down, Miss Graham. Or were you saying something else?
Yeah, I was saying something. I just wanted to let you know that I was in contact with the establishment yesterday evening. They had a
Hold on. No, you need to talk to Mr. Coughlin.
Okay, will do.
So call him and speak to him.
Okay.
So if you ever
Apologies, if you guys can hear me, I cannot
yes, sir.
hear anything right now.
Yes, I can hear you, sir. Can you speak to Miss Graham? Just have a conversation with her and let me know what's going on, please. And you mute yourself, sir, please. Is he not hearing me? No, he's not hearing me. Miss Graham, why don't you just get offline, not offline, just take yourself off camera and give him a call if you have his direct number and talk to him, please.
Will do. Thank you.
All right, thanks.
Oh, this is Andrew.
You need to mute yourself, sir. I can't mute yourself, please. All right. Mr. Coughlin, you can unmute yourself and if you can hear me. He's not hearing me. Sir, can you unmute yourself? Mr. Coughlin, can you unmute yourself and provide me an update with where we are, sir? All right, he can't. I'm speaking. Can somebody get in contact and tell him that we're in the middle of a hearing? I need him.
I'm calling him now, sir, to let him know.
I could hear him before, so what happened? Mr. Charles, can you please put the login information in the chat and Mr. Coughlin to log off and follow the direction that you're going to put in the chat for him to log back on.
Yes, I could do that. He also requested a call-in number, and I provided that to him along with the access
I don't
code.
need him to. I don't know. No, he
Okay.
can't be calling. He has to
Gotcha.
participate online.
Okay.
Thank you, sir. While we're waiting for the government to get itself together, the next case in our calendar is case number 25-251-00012, 12 after 12. This hearing is rescheduled to September 17th at 10:30 a.m. The next case on our calendar is a summary action hearing, case number 25 ULC 00043, Cap and Stem. This case has been canceled and an offer in compromise has been provided to the board for its review and consideration. So while we're here, and let me do our legal agenda alcohol. The first matter on our legal agenda alcohol is review of a settlement agreement dated July 29th, 2025 by and between the group of 5 or more individuals and Nobu license number, which is case number 25 PRO 00034. I make a motion that we approve this agreement. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
And I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. I'm coming back to this case, but I'm moving on with the calendar. The next case on our legal agenda, it's review of a settlement agreement dated July 10th, 2025 by and between Advisory Neighborhood Commission 1B and Slice and Brewed Restaurant, license number 115871. I make a motion that we approve this agreement. Is there a second?
Second.
Ms. Quinn, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 5-0. Number 3, review motion contesting the service of Board Order number 2025-239. This is in case number 24CC00013, license number 1199980. I make a motion that we deny this request. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. The next matter on this agenda, number 4, review of a recipe for dismissal. This is Dos Torres Taqueria. License. This is in case number 24CIT00698. The license number is 125173. I make a motion that we approve this recipe of dismissal. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 5-0. Mr. Coughlin, can you hear me, sir?
Yes, I can. Can you hear me?
All right, yes. Okay, so I'm recalling case number 24CIT00829, Kitchen plus Cocktails by Kevin Kelly, DC, license number 123472. Will the parties please identify themselves for the record?
Andrew Coughlin, Assistant Attorney General for the Office of the Attorney General.
Spell your name, sir, please.
ANDREWCOUGHLIN.
Good morning, sir. I see the licensee is not here this morning. Is the government prepared to move forward without the presence of the licensee?
Yes, Chairman Anderson, we are prepared to move forward. However, there's just an update that I failed to present to the board. So it looks like, I think Chairman Anderson, you said 24CIT00829. I have a slight amendation.
28. I'm sorry. It's 24CIT00828. I apologize.
That's what I have. Thank you. I just wanted to correct it for the record. It looks as though there is I spoke to the attorney for Kitchen Plus Cocktails, and there's a pending case against them, 25CIT00384. The attorney wished to settle that case as well, along with 828, in a global offer and compromise. That global offer and compromise was relayed to the director of ABCA. He has yet to send over the global offer and compromise. So that's just sort of the status of where 24CIT 828 is. So
would you want us to continue this matter because you believe this matter will be settled?
That is correct. That is correct, Chairman Anderson. Yes, if we could continue 24CIT 00828, and it looks as though the attorney for Kitchen Plus Cocktails would like to resolve both matters.
All right. Then, with that said, then the board will continue this matter to a date to be determined pending resolution of the matter. Okay. All right. Mr. Coughlin, are you there? All right. We'll continue this case to a date to be determined. Thank you, Ms. Graham. Mr. Coughlin, the board will continue this matter to a date to be determined pending receipts of an offer and compromise, if one is if one will be provided. Okay? All right, thank you. All right, let's move on to our legal agenda, medical cannabis. On this agenda, there is review of a motion to intervene. This is the Garden DC. This is in case number 25 ULC 00057. The board had approved, we had a hearing this morning, and the board had voted to approve the party to intervene in that in the proceeding. So the board voted to approve for the party to intervene in the Garden DC in that case. The next, the board had voted 5-0 to agreed 5-0 for them to intervene because we did have a hearing on that matter earlier this morning. The next case on this agenda, review of a letter from Carl Smith. This is an FYI to the board. Let's now move to our legal agenda addendum. And on the legal agenda addendum, there is one matter, review of settlement agreement dated July 22nd, 2025, by and between Advisory Neighborhood Commission 2E, the Citizens Association Georgetown, and Jinya, Jinya Ramen Bar, license, and this is in case number 25 PRO 00061, license number 132205. I make a motion that we approve this agreement. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to our legal agenda, medical cannabis addendum. On this case, on this agenda, there's an offer in compromise. This is in case number 25 ULC 00043, and this is cap and stem. The offer in compromise is as follows. Number one, products not to be offered, exchanged, or sold. Respondent confirms that it has ceased selling cannabis products and Schedule I substances and agrees to not offer, exchange, or sell either in the store or online the following products: cannabis or cannabis-derived products, including all cannabinoids, hemp and CBD, creatinine, and any Schedule I substance, including psychedelic mushrooms and dimethyltryptamine, dimethyltryptamine, otherwise known as DMT. There will be a $5,000 fine. Remediation. Respondent will change its business model to a legitimate convenience store retail operation under the trade name Cap and Stem Plant and Wellness. Before lifting the summary closure, respondent shall provide documentation to the board that it has changed its trade name with the Department of Licensing and Consumer Protection. Number 4, inspection. Respondent agrees to allow ABCA investigators to inspect the entire premises of the business during those hours that it is open to the public to verify that the business is not selling those products listed in paragraph 1 until such time as a medical cannabis retail license is issued by the ABC board. Number 5, licensing. Notwithstanding paragraph 1, nothing in this OIC precludes respondent from applying for a medical cannabis retail license. Number 6, lifting of the summary closure. The current summary closure shall remain in effect until the multi-agency cannabis enforcement team, MCET, has inspected the entire premises. The current summary closure shall remain in effect until the board is satisfied that the requirements of paragraph 1, 2, and 3 have been fulfilled. Respondent shall file a motion to lift summary suspension showing it has satisfied the terms of paragraph 1, 2, and 3, and the district agrees not to oppose the motion should it agree that the terms have been met. With that said, I make a motion that the offer in compromise be accepted. Is there a second?
Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Let's now do our licensing agenda. The first matter on licensing agenda, review application for stipulated license with a licensing agenda alcohol. Number one, review application for stipulated license letter of ANC support for Sidewalk Cafe endorsement. This is from Amparo Fondita, AMPARO FONDITA. The license number is 124404. I make a motion that we approve this matter. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passes 5-0. For number 2 through number 7 on this agenda, I am going to read the agenda. I'll make some recommendations, and at the end, I'll ask the ABC board to approve the recommendations as put forth by the chair. Number 2, review application for change of hours of operation. This is for Sound Bar. The license number is 122864. Recommendations for placard. Number 3, review application for change of hours inside the premises for the Sidewalk Cafe and the Summer Garden. This is for Wingo's. License number 1C07. Recommendation is placard. Number 4, review application for entertainment endorsement to provide live entertainment inside of the premises only. Again, this is for Wingo's. The license number is 1C07. Recommendation for placard. Number 5, review application for carry out and delivery endorsement. This is for Wingo's. License number 1C07. Recommendation approve. Number 6, review application for Sidewalk Cafe endorsement with 8 seats. This is for Honey's, license number 126709. Recommendation placard. Number 7, review application for change of hours. This is for Brooklyn Fine Wine and Spirits, license number 132212. Recommendation approval. I therefore make a motion that ABC board members approve the recommendations as put forth by the chair. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. We now move to the alcohol license supplemental agenda. Number 1, review application for temporary operator retail permit. This is for Shoal Wine and Spirits, license number 132529. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the cancellation agenda. The ABC board will be canceling the following licenses for the reasons outlined below. Extreme Pizza, license number 12794. The licensee requests cancellation. I make a motion that ABC board therefore cancels this license. Is there a second?
Ms. Quinn, I second.
Ms. Quinn has seconded the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passes 5-0. We now move to the temporary one-day and substantial change license, agenda. There are 14 applicants on this agenda. I will review the names of all 14, what's been requested, and I'll make a recommendation at the end. I'll ask that the ABC board members vote to approve the recommendation as put forth by the chair. Number one, with a request from Mary Melchior, Melchior. This is for one-day license class F, a birthday party, August the 9th. The license number is 133424. For the attendees, one security guard, recommendation approval. Number two, a request from Todd Rudolph, one-day license class F. This is for Church Oktoberfest. This is September 27th. The license number is 133453. 150 attendees, 3 security guards, recommendation approval. Number three, a request from Nicole, Nicolle, Serna, Serna, for one-day license class F, Gala, September 19th. The license number is 133449. 100 attendees, 2 security guards, recommendation approval. Number four, a request from Zhang Zhu, Zhang Jiang XU, one-day license class F, showcasing Chinese culture, August 30th. The license number is 133459. 1,000 attendees, 23 security guards, recommendation approval. Number five, a request from Javion Gibbs, Jaivon Gibbs, one-day license class G, cultural event, August 24th. The license number is 133428. 600 attendees, 10 security guards, recommendation approval. Number six, a request from Michael Smith, one-day license class G, NIP and SIP, August 8th. The license number is 133445. 200 attendees, 4 security guards, recommendation approval. Number seven, a request from Daniel Daily for one-day license class G pre-opening party. This is September 4th to September 7th. The license number is 133450. 100 attendees, 3 security guards, recommendation approval. Number eight, request from Benjamin Slygod, Slynggstad, a one-day license class G, a wedding, October 24th. The license number is 133458. 150 attendees, 3 security guards, recommendation approval. Number nine, a request from Robert Jordan, one-day license class G, private event, August 9th. The license number is 133460. 60 attendees, 2 security guards, recommendation approval. Number 10, a request from Susan Wells, one-day license class G for wedding, September 27th. The license number is 133470. 110 attendees, 3 security guards, recommendation approval. Number 11, a request from Takera Al Lado 2 LLC, one-day substantial change for the festival. Nature of substantial change, seeking to extend patio to the Street for H Street Festival. This is September 20th. The license number is 119979. Substantial change license is 25 SC 01039. Recommendation approval. Number 12, a request from Calvert Woodley Fine Wine and Spirits, one-day substantial change, tasting. Nature of substantial change, requesting to use license off premises and licenses adjacent parking lot for tasting, August 24th. The license number is 129694. Substantial change license 25 SC 01044. Recommendation approval. Number 13, a request from Fete Oasis, one-day license, one-day substantial change, reception, substantial change, requesting to extend hours of operation, sales, service, and consumption from 1 a.m. to 3 p.m., 3 a.m. This is on August 15th. The license number is 129034. Substantial change license 25 SC 01046. Recommendation approval. And number 14, another request from Feta Oasis, one-day substantial change, reception, nature of substantial change, requesting to extend hours of operation, sales, service, and consumption from 1 a.m. to 3 a.m., August 23rd. The license number is 129034. The substantial change license 25 SC 01047. Recommendation approval. I therefore make a motion that ABC board approves the recommendation as put forth for the chair for the temporary one-day and substantial change docket. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. We're now on the board's alcohol license administrative docket. Without objection, I make a motion that all applications, the 21 applications on this docket be approved. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the medical cannabis licensing agenda. There are 2 applicants on this agenda. I'll review. I'll provide some recommendations, and at the end, I'll ask the ABC board members to approve the recommendations as put forth by the chair. Number 1, review of standard application for a new retail license with delivery, safe use treatment facility, and summer garden endorsement. This is for High Class DC license number 129373, recommendation placard. Number 2, review of safekeeping request. This is for Mr. Nice Guys 2. The license number is 127919. Recommendation approved through March 31st, 2026. I therefore make a motion that ABC Board approves the recommendation made by the chair for the medical cannabis licensing agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Ms. Quinn,
Quinn, I agree.
Mr. Grant,
Mr. Grant, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. We now move to the medical cannabis licensing administrative docket. On this docket, there are 3 applicants, and without objection, I make a motion that the ABC Board approve the applications on this docket. Is there a second?
Quinn, I second.
Ms. Quinn has seconded the motion. We have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. So we are at the end of our agenda and we're also at the end of our calendar for the morning. And so the board will be in recess until 1:30. I ask all board members to now return to executive session for further action. Good morning, good afternoon. Thank you. Good afternoon. We're in the record. Good afternoon. Welcome to the afternoon session of the ABC board. My name is Donovan Anderson. Joining me this afternoon are 4 other board members: Mr. Silas Grant, Ms. Terry Janine Quinn, Mr. David Meadows, and Mr. Ryan Jones. The board has 5 members in attendance this afternoon, so that constitutes a quorum. So let's quickly go through our calendar this afternoon. I'm going to call the cases that we have out of order. So let me call case number 25 PRO 00034, Noble, license number 100894. This hearing has been canceled due to submission of a settlement agreement. And so the only case that we have on our calendar this afternoon is case number 25 PRO 00004, the consortium, license number 130329. Good afternoon, Mr. Charles. Can you please elevate the rights of the parties in this case?
Robert Jordan here, present.
You need to be on camera, sir. Are we waiting for anyone else? I see. Are there any other parties, or this it? Is this it?
Commissioner Ward is unable to attend due to a family emergency.
But so these are all the parties for this?
Yeah, all
this
available
hearing?
parties have been elevated.
Thank you. But I guess what I'm asking, all right, good afternoon, it's a protest hearing. So let me everyone identify themselves for record. Ms. Johnson, are you the representative?
Yes, I am.
All right, so can you please spell and state your name for the record, please, and your role?
Yes, Lucretia Johnson, first name spelled Lucrecia, last name Johnson, JOHNSON. I represent a consortium for sustainable workforces. I am their attorney.
All right. And who is the client? Dr. Jordan, can you please spell and state your name for the record? You need to unmute yourself, sir.
Robert Jordan, ROBERT JORDAN.
And what's your relationship to the establishment, sir?
I am the owner.
And Mr. Upright, can you spell and state your name for the record, please?
Yes, my name is Michael Upright, the designated representative from ANC 6C. It's MICHAEL UPRIGHT.
I believe that I just need to put this on the record that I do know Mr. Jordan. And how I know Mr. Jordan is that I live in Ward 7, and he was my ANC commissioner at 7B06. I succeeded him when he moved on, and so I was ANC commissioner for 7B06, I believe 2014. I think it was maybe around 2014 through 2016 or 17. So I do know him because he was my ANC commissioner. However, I don't. It's not my position that our previous relationship as ANC as him being my ANC commissioner, and I succeeding him as an ANC commissioner, will have any bearing on me making a fair determination today. Okay. All right. This is a case that has been postponed. And so I'm not quite sure why are we here today, because it's my understanding that this matter would have been settled. But before I ask the questions, I want to share with anyone, if the board was to issue a decision today granting this license, the hours of operation that the board would grant if it did, the maximum hours of operation that the board would grant today are the hours of operation that were placarded. The board cannot make any decision to make any changes because that was not placarded. If the license is issued and if the licensee at that time wants to change its license, then the licensee would have to file for a substantial change, and requesting a substantial change that is also that can that is subject to a protest. So if this hearing is if I don't know if the ANC, I don't know what the ANC's position is, but if this is a matter of on hours, the maximum hours that the board can grant in this hearing today, if the board decided to issue this license, is are the hours that are listed on the placard notice. Okay, I want that to be clear to everyone. So, is there? I noticed I did review the documents, but I did not review them closely. I do see that there was some settlement agreement or a proposed settlement agreement that was in the record. At protest hearings, the board does not consider settlement agreements, so therefore, if I move any documents into the record, the board would not consider a settlement agreement. These are proposals and decisions that parties make outside of the hearing. If settlement is not reached, then the board does not consider it. So we can't have testimony to say we had a settlement and this is what they agreed to at a settlement agreement. I mean, the only way the board will would listen to that if the parties jointly stated that we have agreed to these terms, and so the board, you can memorialize these terms as part of an agreement, and then we move forward. So I guess because it appears that there's so much conversations. What is the ANC's position? Is the ANC's position that we do not want the board to grant a license? Or is the ANC saying that yes, you can grant them a license, but these are these we need you to have a hearing on certain conditions. So let me ask the ANC. I'm just asking questions. Okay, we're going to have the protest here too, but just to have to see if there's anything I can do to kind of guide the conversation, the hearing.
I understand. Yes. So the ANC does not oppose the licensing, except we have not come to terms on certain the capacity of the establishment. The hours are fine. We've agreed to those, but it is the overall capacity of the establishment we have not come to terms with yet.
Well, the capacity of the establishment, the board, we cannot offer occupancy more than the certificate of occupancy. So I assume that what was the total occupancy load that was provided on the certificate of occupancy, I guess it's 204 because that was what was placarded. So I guess the ANC saying that they don't believe that 204 is significant. That's the ANC's position?
Actually, it is significant. It is too.
No. That's what I'm saying. So the ANC is saying that they believe that 204 is too much. But as I said before, so the board's authority to grant is limited to what is in. So the board can either offer 204 or they can offer a larger number. So the ANC, the board cannot offer more than 204. So one of the things that we could do today is if the parties agree, the board could agree to issue the license with the hours that were placarded, and then we could have testimony on why is it the ANC believes that 204 is too large, and that the licensee would also provide information on why is it that they believe they need the occupancy load of 204. We can, I mean, if the parties agree, we can move forward that way in the sense that the board would issue an order granting the license with the hours of operation that were placarded. As I stated before, we can only approve the hours that were placarded. If the licensee wants additional hours, they would have to file a substantial change, and we go back through this process. So is that what would that be workable for the parties if the board grants the license with the hours that were placarded, and then we can have testimony on the occupancy load, why the agency believes that the occupancy load is too large, and provide evidence and testimony on what number they think is appropriate. The licensee would then offer its testimony why they believe that they need the 204 as per their certificate of occupancy.
Yes, I apologize. I don't have those hours in front of me. Could you?
The hours
state
that
those
were
as placarded?
placarded, hours of operation: Sunday 12 p.m. to 10 p.m., Monday through Thursday 9 a.m. to 11 p.m., Friday 9 a.m. to 12 a.m., Saturday 12 p.m. to 12 a.m. Those are the hours of operation. The hours of alcoholic beverage sales, service, and consumption would be Sunday from 12 p.m. to 10 p.m., Monday through Friday, 4 p.m. to 11 p.m., Saturday from 12 p.m. to 12 a.m. Those are the hours that were placarded, and because since these are the hours that were placarded, the board cannot offer hours exceeding that was on the placard notice.
The ANC does not oppose the hours at all.
Okay, fine. So if the ANC doesn't oppose the hours, then the board we can issue an order, issue the license with these hours, and then we can have the hearing on the capacity, in a sense that, so we just what I would ask that the licensee do is to just, they can summarize what their business plan is, tell us about the business, and why is it that they believe that they need the occupancy load that's on the certificate of occupancy, and the ANC can provide evidence and testimony why they believe that the occupancy load is too much, and what it is that they are proposing the occupancy load should be, and why.
Okay,
Is
that
that,
works for us.
does that work for you, sir, Mr. Upright?
Yes, we're agreed.
Hold on, please. Hold on. Let me make sure my lawyer doesn't disagree with me. So Mr. Upright, what capacity, what is it that you're asking? What is it that the ANC would be asking for as capacity?
We would like to limit it to 100 persons.
To 100.
Yes.
Okay. All right. All right. All right. So, all right. The way do we have witnesses here today, or is it you're going to be the only witness, Mr. Upright? Hold on.
I'm the only official witness from the ANC.
Hold on 1 minute, please. Hold on. Okay, I apologize. All right. So so you're the only witness, is that correct, sir?
Yes, I do have a statement from Commissioner Wirt that I could read, if I may. For that.
I guess you could do that as part of your opening statement. I'll give everyone a, excuse me. It's, yeah, I'll as your opening statement, you could do that as from the ANC, because
It does cover all the points in opposition to the capacity.
I mean, I guess you're representing the ANC, so you can read it as not necessarily from her, but from the ANC, because you're, she's the chair, or she,
She is the chair of the ANC, correct?
and so as the designated representative of the ANC, you can state what the ANC's position is. So you don't, so you're not reading it from her, you're reading it, you're reading the ANC's position, okay?
I understand.
All right. So we'll issue a board order approving the license and approving the hours of operation, the hours of operation, the hours of sales, sales, service, and consumption as per the hours that were on the placard notice. And so this hearing then will be on the capacity. Why is it that the establishment believes that it needs the capacity for 204, and the ANC, why is it that they believe that they need a smaller number, which is 104? And as I stated, that the board cannot, whatever decision the board can make, when it comes to the certificate of occupancy, we can only issue for whatever the certificate of occupancy says, or if sufficient evidence is presented, then the board can decide that they believe that that number is too large, and that depending on the information, then the board can itself come up with a number, either what the ANC proposes, or some of the number, or the number that's on the certificate of occupancy. Okay, I just want to let folks know that that's how we'll come towards making a decision. So for the protest hearing, then what we'll do, the applicant goes first, and so what we'll do is that the applicant can issue an opening statement. The ANC can also issue do an opening statement, or the ANC can defer doing an opening statement until they present their case. Because the board is the parties have agreed that the license will be issued, we're not going to have a board. We're not going to go through the case report to have the board witness testify, and so the applicant will call witnesses, and what I will state is that we can just explain to us the nature of the business. And so the testimony should be regarding the nature of the business, and why is it that you believe that the occupancy load as per the certificate of occupancy should be what should be issued. And once the applicant has called its witness, and then once the applicant calls its first witness and conduct direct examination, the ANC will have an opportunity to cross-examine the witness. Once the ANC cross-examines the witness, the board will have an opportunity to ask questions of the witness. Once the board asks questions of the witness, the ANC will get another opportunity to ask questions of the witness based on the questions that were asked by the board, and then the applicant will then have an opportunity to ask redirect questions of the witness. Once the applicant has presented its case, then the ANC can present its case. And if they have witnesses, they'll call witness. If you're the only one who's testifying, sir, I'll swear you in, and then I'll allow you to testify. Then Ms. Johnson will have an opportunity to cross-examine you, and then the board will have an opportunity to also cross-examine you. So any questions prior to us moving forward?
None for me.
Perfect. All right. So we can start off then with we can do an opening statement, Ms. Johnson.
Okay, I will keep it brief. CSW is a business that has been at that location for quite a while. They operate in government contracting. Recently, and part of that government contracting is providing courses to different students to give them trades in order to advance and create a career and have long-term earning potential. Most recently, they have applied to be a grant to provide classes for bartenders. That way that they can become licensed. And so through that, they will be serving alcohol. For those bartenders to get experience, they are also becoming an event space. In that realm, the bartenders would get the training, the courses required to become properly licensed under the District of Columbia regulations, and then they would serve at these particular events. So far, this CSW has already been holding events without any issues and any disruptions to the neighborhood. In those events, they are applying for licenses per an event, which is, of course, increasing a significant cost, especially in this time period for a business that operates heavily under government contracting. So these events, they are necessary basically to keep to basically increase the revenue that has been significantly reduced for CSW. And like I stated, they have already been holding events at the space on a pertaining a license per an event. There have been no issues or disruptions to the neighborhood. In fact, I don't believe the neighborhood even knew that the events were happening because they have been courteous of their residential and other commercial neighbors. So now I will call Dr. Robert Jordan.
No, hold on. You can hold on a minute. Hold on a minute. Mr. Upright, do you want to make an opening statement now, or will you defer until the ANC presents its case? I can't hear you, sir. You need to come off. You need to unmute yourself.
My apologies. No, I'll go ahead and make my opening statement, which is just where we restate our position regarding the capacity. The ANC is protesting this application based on three areas: the negative effect on peace, order, and quiet, the negative effect on property values, and the negative effect on vehicle and pedestrian traffic. The reasoning on the part of the community is that the applicant's establishment has occupancy for 200 people. Events for this size group would bring in outside vendors that could easily overwhelm the neighborhood. Residents in the condominium located at 201 Massachusetts Avenue Northeast, directly above the consortium, will be exposed to noise and conversation at curbside as such a large group of patrons enter and exit the premises at such a large event. Let's see, the condominium units above the consortium on the side of 201 Mass Avenue will see a drop in the sale value of this because of this disturbance. Excuse me. Vehicle traffic at the corner of the establishment where Massachusetts Avenue, 3rd Street, and D Street converge will worsen with drop-off and pickup of a large number of patrons before and after events. In addition, D Street is a major through street to the freeway entrance for vehicles heading for Virginia. The pedestrian sidewalk will be blocked by a large group of patrons, causing passerby to step into the street to walk around each large group. Parking on nearby neighborhood streets on Capitol Hill is extremely scarce. An influx of large number of vehicles for events of this establishment not easily find parking, likely resulting in double parking, traffic slowdowns, honking, and other problems as would-be parkers circle the neighboring streets. We have also spoken with the residents of the condo building and nearby residents of the establishment. Nobody opposes them being there at all, but we do oppose it is strictly in opposition to the sheer number of attendees. And we don't believe their current events have 200 attendees. Matter of fact, it's substantially smaller than that and has not caused a problem to date.
Is that it?
That's all. Thank you.
Thank you. All right, Ms. Johnson, do you have a witness you wish to call?
Yes, I'm going to call Dr. Robert Jordan.
Dr. Jordan, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
You're a witness, ma'am.
Thank you. Dr. Jordan, how long have you been at the location?
We moved into this location October of 2020.
And in October of 2020, you were renting and then later became an owner?
Correct.
So you've been at the location for just under 5 years?
Yes.
Okay. Can you confirm the anticipated uses of the license?
We are trying to figure out creative ways to generate income for the graduates of our certification and occupational training programs that are servicing at-risk populations across the District of Columbia. So we are doing everything from having culinary students and people taking our special police officers, licensing course, work management retreats, conferences for DC government, receptions, retirement parties, birthday parties, etc., as a way to generate income and paying jobs for our students.
Have you currently been holding events where alcohol is served?
Yes,
About how many events have you held so far?
we have held, and I think you can run the number of one-day permits we had, but it has to be over 40 to 50 events.
Is there a particular day of the week that those events are typically held on?
We have
Or does it
done
vary?
90, at least 95% of those events are Friday or Saturday.
Okay. What type of events are being held?
Lots of birthday parties, anniversary parties, Christmas parties. We do support, we had a grant with Events DC to support cultural arts. So we were doing visual artists, vocal artists for those events. And some, musicians, we have violinists as well.
For the contract that was with Events DC for cultural events to be held, how was your guest list created for those? Or does Events DC also send out emails for the events? How do you?
202 Creates Events DC would help us promote the events. Under the grant, the events were free of charge. They were just to provide additional cultural arts and exposure of, and showcase DMV talent in across a variety of creative spaces and genres.
Okay. And so these events are basically kind of sent to everyone that's on 202's mailing list.
202 Creates. There's a DC Mayor's Office of Nightlife that would sometimes repost us in Events DC.
So there is a possibility for the space for you to have 200 RSVPs as stated in which your occupancy license would allow.
Yes, I mean that was the buildings always had that capacity, and so that's what when we purchased the building, it had that capacity. And there could be, if one of those events took off, I guess there could be that many people.
Okay. So the ANC seems to be concerned with, I guess, parking and exiting and the patrons exiting and entering the building. How does the entry and exit happen when there's an event held?
There's a big double door, entrance that people typically go in and out of for entry and exit. We also have two other additional exits connected to our space. One down a shared common hallway connected to the building, and then we have our own exit out of the kitchen area, making it a
So you
total
have
of three.
Okay, it's a total of 3. And patrons, when an event is held, they have the opportunity to exit out of all 3.
Yeah, but typically staff go out of the back doors and the patrons go out of the front door.
Okay. So the ANC mentioned that they would have an issue essentially with vendors maybe overwhelming the space. I believe in one of our exhibits, the contract essentially shows that food has to be provided by CSW. You have to be the vendor, correct? Your culinary students.
Yeah, the majority of events are they're catered by graduates of the program.
I and would like to show, excuse me, a copy of, I believe it was pre-marked as
All
for
right.
identification as Exhibit 6.
All hold on. I'm hearing noise in the background, so I'm not sure where it's coming
I'm so
from.
sorry. I can go to a quiet area.
Yes, sir. All right. So, Mr. Charles, can you allow Miss Johnson to share her screen? So you can share your screen, and once the permission is granted, then you can pull the document up.
I think
So
I think I have permission, so
Yes.
I'll pull it up while
okay.
Dr. Jordan is moving to a different location.
All right. Can you guys still hear me?
Yes, sir. So go ahead.
All right.
Go ahead, ma'am.
Okay. All right. Dr. Jordan, showing you what we pre-marked for identification as Exhibit 6. Do you recognize this document? And can you see my screen?
I can see your screen.
I think I can make it larger.
Yeah, let me try to do the focus too. Okay. Yes.
I am going to scroll down to, well, I'm sorry, what is this document?
This is the web page where people can reserve a date on the calendar for one of their events.
Okay. And you said on a web page. Which web page is it
This is
located
on our, you can access this scheduling system from the 201.dc, I'm sorry, 201dc.com website.
on? Right. This is an accurate representation of the consortium's events, terms, and conditions.
Yep, there may be some minor updates, but that's the standard, terms and conditions.
I'm going to draw your attention to the food and beverage section. You require 10 days notice prior to the event for the details concerning food and beverage, and a guaranteed number of guests is required 5 days prior to the date of the event.
Yes.
Okay. Does this allow you to properly plan for arrival and exit of patrons?
Yes.
Okay. Showing you the audio visual section. The agreement states that basically you cannot bring in any outside audio and visual except a laptop. So CSW is able to control the noise associated with any music or presentations.
Correct.
Right. And then I'm just going to scroll down to the food and beverage section where it states that only food and beverage purchased from the consortium may be served in the consortium premises.
Correct.
Right. And so to do that, you all essentially, basically, the executives there and the culinary students go out, purchase the food, and prepare it in the kitchen there prior to the start of the event.
Correct.
Is there creating any extra or additional traffic by students and executives that are already scheduled to be at the building?
No.
Right, we are going to ask, and sorry, Mr. Chairman, I'm not sure if you would like for us to admit it as 1 since it's our first exhibit, or ask for admission as 6 is how it's marked.
We can, well, this is the first document you're asking, so we can, Exhibit 6.
Okay.
All right, so Mr.
So we are
Upright,
asking
do you have any objection? I can't hear you, sir. You need to unmute yourself.
I'm sorry. To this document, no.
All right. So without objection, so we're going to admit Exhibit 6 to the record.
Thank you. I'm going to stop sharing my screen briefly so I can scroll to the next exhibit.
Okay.
All right. Just for completion, I'm going to have this next one admitted, even though I know the board already has the information. Dr. Jordan, showing you what has been pre-marked for identification as Exhibit 7. Do you recognize this document? Okay, and what is it?
That is the certificate of occupancy.
And the number of seats that's allowed for this certificate, for your location for the certificate of occupancy?
Is 204.
And how much square footage does your unit have?
6,000.
All right, and we are going to ask that applicant's Exhibit 7 is admitted.
Mr. Upright, any objection?
No, sir. No, we don't. We do not.
So without a objection, Exhibit 7 is moved into evidence.
Okay, and now I'm going to show what has been pre-marked for identification as Exhibit 8. I am going to scroll Dr. Jordan because it's a couple of pages so that you can see all pages. Do you recognize this exhibit? Hey, what is it?
That is Studio B.
Okay. And what is Studio B?
That is the recording studio we designed for our media arts programs and where we have our Avid Pro Tool instructor teach out of.
Okay. And looking at the second picture on this page, what is it?
That is the full layout of the building, of our unit.
Okay, this is like a 3D rendering.
Yes, correct.
Is this area here where the bulk of the patrons of an event gather? I'm not sure if you can see my mouse circling. It's the top left.
I would have to say depends on the size of the event. If it's 30 people, they typically want that front room. And it also just depends on the type of event. There's 3 separate rooms that are each kind of self-contained. So depends on what the client needs, they'll use the appropriate room.
Okay. Looking at this rendering, can you point out which rooms are the 3 separate rooms that are available? This is one, correct, at the top
Yep.
left. Okay, and the second one is
We
the
call
one
that
in the back, I believe.
so then that white in the middle, that's the white room. We call that the studios.
Okay.
And then in the back, we call that the salon.
Okay. And the 40 plus events that you've held so far, those you have utilized all 3 of these rooms at some point?
On a handful of them, like under less than 10 have ever
Okay.
used all 3 rooms.
Okay. All right. And then this is I guess a close-up of the kitchen area, the commercial kitchen.
That's
I
the
mean,
front bar.
the front bar. Okay. All right. And then let me see if I can.
That's the back salon. Yeah.
This is just the bathroom. And then this is the back salon, one of the third
Correct.
spaces, correct? And what's this at the bottom?
That's the back of the salon.
Okay. And these are just additional pictures of the salon and then another bathroom, correct?
Correct.
Right. So we ask that Exhibit 8 be admitted into evidence.
Mr. Upright, any objection?
No objection.
Exhibit 8 has been admitted to the evidence without objection.
All right, and Dr. Jordan, if you were to have an event of 200 people, can you walk us through how you would handle the entry, exit, and arrival?
So the entry of 200 people, we always have security for that many people. And the entry would be coming in from the 2nd and D Street corner. Staff would be able to enter from the kitchen entrance as well. Then upon exit, there just be an orderly exit out of the kitchen exit and the front entrance. And the front entrance is a kind of oversized, I think it's about 16 feet across entrance, with 2 big double doors that open fully. So it's just your typical kind of egress and regress.
Okay. And for your location, are most patrons coming via rideshare, metro? Because it is known that there is not a lot of parking available in that area. So how do most patrons arrive?
So most things that we do, we always advertise rideshare being advisable, mainly because it's a safety thing with the alcohol consumption. Also, it does help with the parking. We also advertise that Union Station is a 2-minute walk away from us and has ample parking, and then there's limited street and metered parking around the building.
Okay. Because it seems that you're holding family events with the exception of the DC events, do you ever have an issue with, I guess, patrons lining up on the sidewalk? Like there's no entry requirement, you're just able to let them in, correct?
Yeah, there's never been a issue of too many people wanting to get in. Is that the question?
I was asking more specifically, the ANC seems to have concerns that people arriving to the building would start to create lines, kind of almost like how you see, let's say, a line waiting to get into a concert or something, like that they would create some lines on the sidewalk.
Yeah, there's not a we don't have that problem.
Alright. I do not have any additional questions.
Okay, Mr. Upright, do you have any questions of Dr. Jordan?
I do, sir. So, Dr. Jordan, what is the typical size of the 40 to 50 events that you've held to date, patron-wise?
Typical size is 35 to 40.
So, have you had requests for higher numbers that you've
Yes,
had that
I can
you've
specifically the time zone. It's only a couple times a year. There's a group called the Southern Diplomats that they do a Christmas party, and they go over 100 people. They're definitely gonna have, they have a large organization. So it's only typically over the course of a year, only the Southern Diplomats get close to 200 people. And it's a one-time Christmas party they do in December.
But you've never hosted that to date, correct? Or you have?
No, we've hosted at least 2 of them.
What were the? I'm sorry. Go ahead.
No, it's just yeah. There's a Christmas party with Southern Diplomats. They are the only group that has ever gotten close to over 100 people.
And did you have people? I mean, did you have crowd control, noise, and other traffic mitigation in effect in place?
Yeah. So again, they were emphasizing the use of public transportation and rideshare, and we had, security staffed. It created a lot of good jobs for our students, and it was perfectly fine.
Great. So most of the patrons that are attending these events are not local to the area.
I don't know where everyone
as the immediate area. I'm sorry. Let me rephrase that. As in the immediate Capitol Hill neighborhood that surrounds the consortium.
I don't know. I can't answer that definitively.
Okay, you have stated that you do use your culinary students to provide the kitchen help, etc. What kind of how often are deliveries for food and so on? For those
We haven't had DoorDash or Uber Eats app operating in the past 7 months?
I'm actually not, I'm sorry, that's not quite what I meant. When you have an event, you have food brought in for your culinary students to prepare for these events, if I'm not mistaken. How often are those deliveries? And when do those occur?
Mr. Brox brings them in the day of the event. And he's right now he's only working Friday or Saturday. He's only working when we have an event.
Okay. So this is just a single individual
Mm-hmm. It's
making these
typically a
deliveries?
single. It's just typically the chef or the head cook that is bringing in the food, and they get the groceries. They bring the groceries in themselves.
Okay. You mentioned the exits. You mentioned a common hallway. Have you ever used that common hallway as an exit?
Only doing like if there's a fire alarm that goes off, we do evacuation drills and we'll use it. I used it this week because there was the batteries were dead in the front door. So it's available for use, but we typically will use the doors that are connected directly to our building and not the common areas.
Okay. Would you ever consider using that exit during one of these larger events?
In case of emergency, I think that's why it's there. It's also an exit door,
So
emergency exit door.
you're saying only in case of an emergency, generally. You would not use that as an exit for a standard exit for an event.
People don't use that as an exit.
Okay.
I think they're fearful of the fire alarm going off because it has a sign on it for that.
Gotcha. Okay. You also mentioned the kitchen exit. Where does that lead?
It leads to the back alley staircase.
Okay, and the back alley does back up into residential units, does it not?
There's a building on the other side of the alley with our building, and then there's the alley. Then there's another building on the other side of us. So it's just an alley. There's trash cans back there. It backs up to the trash cans.
So
Really.
this is not typically used for patrons to exit.
Only people that go out there is the maintenance crew and the staff to throw away trash, to be honest with you.
Okay, and speaking of trash, when is that emptied? Is that emptied late at night?
The trash schedule is managed by the condo association, and I know they've changed vendors a couple times since I've been here. I don't know the exact schedule of pickup.
I'm sorry, let me restate my question. When does the consortium empty their inside trash to the?
I want it emptied every event. At the end of every event, we don't want any food left in any containers, any trash cans exposed.
So if an event ends at midnight, there is possibility that your staff could be emptying trash into the alley, where I assume the trash cans are, based on what you said, after midnight.
Yes, we want them to empty it before
Okay.
they leave.
And
whatever time it is.
what do you do about the noise that's generated by that?
Throw trash going into a dumpster in the back alley. I have no plan for. It's yes, we empty the trash, same as any other business
Okay.
or resident uses the use of that trash can as well.
I'm sorry. Would you state? I'm sorry, I didn't catch that. Would you say that again?
It's just a trash. It's just a dumpster in the alley that all the residents and tenants of 201 Massachusetts Avenue use.
Okay. I understand that. I'm just worried about they don't typically have the volume of trash at midnight, though, that your establishment would generate. So it's concerned about the noise that hour and the time after every event. How many events do you anticipate potentially having per year?
I would I really would love to have Friday, Saturday, and Sunday have some type of programming each week. that would have the biggest outcome on job creation and recycling income back to the students. We're struggling to get to be that sustainable and generate income at that level. But that's the goal.
Okay. Do you plan on when we first met with you back in January through ANC 6C's ACL committee, you stated at the time you were training your bartenders up, which was we as an ANC definitely support. But you all, I believe, and I was present for that meeting. My understanding coming away from that meeting was that you were going to open up you wanted to open up an establishment that not only just had these special events, but also you were open daily,
Happy
like
hour.
you operated as a tavern basically, so that you would a Class C tavern.
So the issue with that is, it's going to cost you $400 a day to open up that tavern and just labor cost. And what we found out is we don't have a consistent enough clientele to survive that $400 labor cost per day. So we do better just opening up when we know there's going to be an event. Because we're not primarily in the restaurant industry, which is a very serious industry that has a lot of people going out of business right now. It's better for us to slow roll that out, because when we have tried to have a weekday Monday through Thursday happy hour operation, we're losing too much money. We're not competitive with all the other options available in the DC area, and it's a very tough business.
So but you would like to eventually get to that point where you have a Monday through a weekly establishment open Monday through Saturday, or I'm sorry,
That would
Sunday through Saturday.
that would create 4 full-time jobs if we were able to do that, plus work experience for people coming through the training programs. So, but again, you have to be a pretty good operator to maintain a daily restaurant operation.
Mhm. Do you feel you could survive with these special events with less than 200?
No, it's hard to survive in the food and beverage industry, period. You need some big wins at some point to cover the losses that I just described, when there's nobody showing up, but you've paid 4 people to do the kitchen, the bar, maintain the bathrooms, and you only had 10 patrons.
Okay.
You definitely need it's nice to have a couple large events to cover up the bad events.
You mentioned I'm sorry, I forgot the name of the group. You that you hosted over 100 people.
Mm-hmm.
How was security and crowd control, traffic mitigation, et cetera, handled then, and what were the effects on the local area?
There was 0 effects on the local area. It was a well-attended event. People enjoyed themselves, and a lot. I think the Southern Diplomats also donated proceeds and had a toy drive as well for the local area.
Okay. Yeah, let me see. Did you review the ANC's settlement agreement that we typically sign with every applicant?
I'm going to object here. The terms of a settlement agreement aren't relevant and not admissible, and I believe Chairman Anderson has already explained that before we even started.
No, the question is that have you read the settlement agreement that we have for other establishments? So it's not specifically to this establishment. I think it's more of a general question. So I'm going to allow the question, but as I said before, if we're going to talk about specific discussion regarding this establishment, I'm not going to allow that. But this question, because it's have you read the settlement agreement that we have for other establishments? I'll love that question. You can answer it, sir, if you can.
Is this from the ABRA board or from ANC 6?
This is from ANC 6C. This is a standard agreement that we utilize with every applicant.
So I read at least 3 versions of the settlement agreement from ANC 6C.
Yes, we did try and negotiate this beforehand.
No, we're not. All right. Remember, we're
Yes.
not talking about negotiating. I mean, I thought you were just asking a question.
I was asking. I didn't know if he read it.
All
So
right, just
I retract the last question.
All right. Okay. Okay.
So, okay. Thank you, Dr. Jordan. That's all my questions at this time.
All right. Any questions by any board members? Go ahead, Ms. Quinn.
Yeah, what is the largest capacity event you've hosted?
It'd be the Southern Diplomats. They had I believe 165 guests.
And did you have any complaints from neighbors?
No.
And what are you representing that you can't imagine an event where you'd have outside vendors making any kind of delivery?
No, and to be clear, we have had Dunkin' Donuts and Papa John's bring in pizzas I've ordered it for staff, and we've had the Department of Health and Disby do events here, and obviously we just have some donuts and coffee sitting out for them. We'll order that. It's sometimes cost prohibitive to bring in the whole culinary crew for that. So yes, what we're talking about is we don't allow outside catering without permission and without certain licenses and certifications. So you need to have a ServSafe food manager license. You need to be properly qualified as a caterer, because that clause is really intended so that if people ate something and got sick at our establishment, they wouldn't necessarily associate it with the cook. They would associate it with the building, the consortium. And we need to make sure people are properly licensed, and also the goal is to generate jobs and income for the students. It would only be, like I said, a Papa John's type of situation, Dunkin' Donuts, just for a meeting, presentation, conference, workshop, where we'd have an outside vendor deliver some food.
So how would you acquire the alcohol that you'll serve?
I believe we have to go through the distributor and then once we have a proper ABRA license, we could have a relationship with a vendor. But we know that just because we have tried, we know that we have to have that license in place before before the liquor distributors will start delivering to us.
And then you'll have a vendor delivering. So how would that be handled when you get so far as to having this relationship with a distributor and they then need to deliver alcohol to your building? Have you imagined how that process will be handled? Would it be in the back of the building? Would it disrupt traffic? Anything that you know about how that might look would be helpful to understand.
I think to limit the amount of traffic, it would be to kind of not create any new traffic. So the Union Pub on the corner has deliveries multiple times a week of kegs and liquor, and they pull up with their truck and dolly and offload in front of their building.
Okay.
It might be helpful just to use the same vendor, so they can keep the existing delivery and then just also service our location and not create any additional traffic.
All right. Thank you.
Any other questions by any of the board members? Go ahead, Mr. Meadows.
Good afternoon, Dr. Jordan. Are you, so right now it's going to be event only, correct?
Right now we're doing events only, and we don't have any in the foreseeable future. We don't have a good plan in place to do any kind of a daily happy hour. We on, like I said, that would be good. It would create the jobs we're trying to do and more opportunities for work experience. But all at the same time, I think I saw they're in the headlines last week. They're saying 40% of restaurants are going out of business in DC.
Sure, sure. Yeah. So you're getting a tavern license. When you are training the workforce participants, you won't be training at the same time you're having an event, correct? Like you're not going to have you do beauty salon training, you do restaurant employees training, correct? So those things are not going to happen simultaneously as a private event.
Actually, that's something that we do want to do, is give people real world experience. So, for example, the security guard program, you do your online coursework. After you finish that, you're eligible to do the 1 day intensive training to do like baton, handcuff, OC spray. And then we want to have you work and shadow one of our security guards at an event. That way, when you go to a job interview, you're not just saying that you've sat in a class, but you can say that you've worked in the field. So, and we try to use that same model for all of our occupational trades. So we do that for the drug testing, the phlebotomist, and the bartender and the culinary. We do want to get you on the actual floor working at the end of your program as a capstone assignment.
And that makes sense. That makes sense. To get not only the training, but the real world experience of it.
Yeah.
But from what I see, what you're trying to do is to kind of expand into hopefully a Friday, Saturday weekend type, where you can pick up on your events more there, and then perhaps maybe go somewhere a year or down the line into a daily business where you get business walking in off the street. Or do you?
I mean, I would say yes. I mean, it would be nice to get to that point. But we've done enough to know that it's not an easy task to try to go into the daily operation.
Sure.
You can lose a lot of money.
And I'm asking that question because, if you were going to have an event simultaneously, because, the certificate of occupancy, it does say 204 on it. And I don't know, I assume that is for the entire, I believe you said about 6,000 square feet, I believe. So I'm in my brain, I'm trying to figure out if that's for the entire space or just the front where the main bar area space is, if that makes sense to you.
Oh yeah, here. So
Yeah.
I think I can answer. So when we do an event, we typically, even if it's a small event of like 40 people, it's closed to the public.
Sure.
And I think there may have been one situation where somebody wanted to have the customer wanted to have a small kind of office happy hour in the back salon, and then and keep the front area open so people could mingle between both. And there might have been some you know uh one of our cultural events going on in the front, so that they wanted to have some crossover or second kind of some other activity for them in the space. But it's happened a handful of times. Typically, if somebody rents the space, the entire space is theirs for the rental.
Okay, thank you. I probably 15 years ago, when it was some kind of establishment, I do remember going to an event in that space before the consortium. My barber is right next door to you.
Okay.
And I've been to him for 25 years. So
I swear I saw you one day walking down the street.
Probably
So you were coming out of the barber shop. It was
Is that the hallway that you were talking about, sharing a hallway with
No,
that
so
hallway?
the hallway we share is to the laundry room. That you're
Okay.
above, you're literally above us,
Yeah.
and exactly above us. Yeah, in that
Okay.
barber shop.
Thank you for your answers. Thank you.
Any other question by the board members? I guess let me ask a question, Dr. Jordan. Tell me what's your business model? I mean, I know you apply for alcohol license and you apply for a tavern license. So, what is your business like model? Why are you applying for a alcohol license?
Well, at the time it made sense. So we had just finished the Events DC cultural events grant where we had promised 48 events, and and I think this board has seen we had tons of those 1-day permits getting processed through you guys. So I think the liquor license is like $3,500. So a 1-day permit is $300. So I think after you go over, I don't know, 15 1-day permits, you start to it starts to be more cost advantageous to do the liquor license. And that's why we, at the end of the fiscal year, we said let's go ahead and get the liquor license because the Events DC grant was ending, and part of our sustainability pitch to them was we can keep these events going if we don't have to have a $300 upfront fee. We'll use let's use the remainder of our money that we have to use up to put it toward a government permit.
So, are you what's the main focus of your
We are
establishment? I'm
we
sorry,
are
go
a
ahead.
we're a social enterprise experimenting with different formulas to transition people from government benefits to the job market and local economy.
So you don't consider yourself like a typical, you're not like a typical, it's a tavern license, but you're not gonna operate as a traditional tavern in the sense that you're open every day, you're selling alcohol, and this is your, because as a tavern you don't have to sell food, so that's why the difference between a tavern and I'm asking, so yeah.
No. We collect more urine samples than we do Jack Daniel. you know, testing in here. We're doing background checks. We're doing cosmetology courses during the day. The tavern is required to operate our model the same way we run all these other models where we're teaching the trade and performing the service as a way of having a better classroom experience for residents of DC.
All right, now the issue, I mean, the ANC agreed earlier, and so you are going to get your license, so you are going to get the hours of operation and service that was noticed on the placard. So the issue now has to do with the capacity. Your certificate of occupancy says 204. Why do you need 204 people? Why you need that 204 capacity?
It is a nice to have. You don't need a V8 engine to get on 295, but it's nice to have that capacity when you need it. So, and that's just what, when we converted this from a lease to a purchase, we purchased it as a 204 capacity space. I don't think it's appropriate to limit the functionality of the purchase post transaction. And I don't know if that's kind of aligned with and especially in a market that's already suffering. You don't want to handicap anybody's ability to be successful.
Now, the ANC is asking, I mean, the question I'd asked earlier, in trying I'd asked the ANC what capacity they were seeking, and they said 100. So what's your view on that?
It is, I'd love to have 100 people. It's hard to get 100 people out. Only time I've had 100 people come to any of my events is my wedding, right? And that's what people learn in this business very quickly. You are hoping to get over 100 people at some point, but it doesn't happen very often. And the goal is to be as have as many capabilities as possible when trying to run a business, and you just don't want to impose restrictions when everything was done in good faith. The Department of Building did their job and assessed it at 204. It's historically always been 204. I don't think I'm doing a good job as an owner operator to artificially limit it to a lower number without just to do it. I mean, I don't know why they came up with the number of 100. So the building still has the cost associated with a place that can fit 204 people. It has the electrical bills of a place that can service 204 people. You have, the heating that for 204 people, but now you're going to limit the earning potential to 100. How is that small business friendly?
Mr. Upright, do you have any questions of Dr. Jordan based on the questions that were asked by the board?
Actually, I do have just a couple more questions. Dr. Jordan, there's also...
They have to be based on the questions that were asked by the board, sir, okay?
Okay, well, he mentioned the building that they reside in. There is also another establishment in that same building, the Union Pub.
Okay, go ahead.
So that's a lot of traffic between the two establishments for the condo building residents to have to live through. It seems like expecting a couple hundred people more, that would just increases the chance for a lot of noise and disruption in their lives. And have you approached the condo board and asked them as far as how their residents feel about it, and for any assistance, and what they thought you could do to mitigate and make it more acceptable, palatable to the residents inside the building in which the consortium exists?
Objection. This seems to be outside of a question that the board asked. It also seems like Mr. Upright is trying to kind of go around and still discuss settlement negotiations. And he knows it because he provided those written documents.
The condo board does have an objection to this establishment. Yes,
but
Dr. Jordan, I mean, you stated you're in this condo building, which you're jointly sharing with other residents. What conversations have you had with them?
Well, that's going. I mean, there's no requirement for him to have a conversation. That's going across the track. I think also one of the things that is upright, some entity determined that the maximum capacity for the space is 204. That's some entity, which is not us. And as I told you before, the most that our agency can do, we can either give 204 or a different number. We can't give 205. We can only give 204 or a different number. And so that conversation, it's not for this. I guess this conversation is not for this forum in that sense, in the sense that you're asking him, has he spoken to the condo board and stuff. So I'm gonna.
I'll retract the question.
All right, save your okay.
I have no more questions at this time.
Okay, fine. Miss Johnson, any redirect?
Yes, just one question. Dr. Jordan, you mentioned Southern diplomats, excuse me, uh, hold an event annually, at least one time a year, and it is 160 people at least. If you were capped at 100 people, would you be able to rent out the space for that event?
No, they would not they would not do business with us.
And I'm sorry, I guess I do have two questions. And you mentioned earlier that you need those events to offset the smaller ones. I'm guessing because you've worked with Southern diplomats for 2 years in a row, that is a significant income stream and revenue that you expect annually from them from holding that event.
Yes, and relationship as well, because they do a lot of positive things in the community. We want to keep some type of, relationship with them.
Okay. Those are my only questions.
Thank you. Dr. Jordan, thank you for your testimony, sir. All right, Ms. Johnson, do you have another witness?
No.
Do you arrest?
Yes.
All right. Mr. I guess it's 2:49. Mr. Upright, do you want to take a break before we move forward, or we can just move forward with you presenting your case?
We're fine with moving forward.
All right. All right. Do you have a witness you wish to call?
I have no witnesses, no.
So you're the only witness?
I am the only witness.
Can you raise your right hand? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Go ahead, sir.
So we do agree. We support the consortium and their goals as far as training people up into jobs such as bartending, culinary skills, and so on, and in general management of establishments of this sort. Our only sticking point with them right now is the capacity. We're just concerned, the neighbors are concerned that it is going to be disruptive to the area. And that is truly our only concern. And I'm sorry, that's it for me.
John, do you have any questions you want to ask Mr. Upright?
No.
Mr. Upright.
Yes, sir.
What establishment was in the space prior to them taking over?
There were two establishments that I'm aware of. I don't know the name of there was a.
But let me ask you, were you the ANC commissioner at that time?
No, I'm not the ANC commissioner now for this area. That's Commissioner Wirt, who cannot be here.
Okay.
So there was a local establishment, I believe. Mr. Meadows referred to it. There was a tavern, Class C, I believe it was a Class C. I'm not positive about that. That was a local hangout for Capitol Hill staffers, primarily for a number of years, which was during its existence was at one time very popular, but obviously it's not here any longer. Before that, according to Commissioner Wirt, there was a Chinese restaurant in the establishment as well. And I don't know the years. I don't know how the length of time or anything beyond that.
Okay.
So there's never been an establishment that would cater to these large numbers.
No, but what do you mean cater to these large numbers? I mean, a certificate of occupancy is a certificate of occupancy. That's what Department of Buildings decide what the capacity is. So whatever we were stating that would be the certificate of occupancy for the building.
Mm-hmm. For the space, yes.
For the space, yeah. So, but since you're not the ANC commissioner for that area, and you were not an ANC commissioner at that time, so I can't ask you any other questions about that then.
Mm-hmm.
All right. Any questions by any board members? Ms. Johnson, any questions of Mr. Upright based on the questions that I asked?
No.
Mr. Upright, and the clarification that I know I asked you, so if you had an attorney, I would have your attorney to ask, redirect. So do you need to provide any clarification to the question that you asked of me?
No, sir, I'm fine.
Do you arrest?
I do.
All right. So this is an opportunity for closing. So basically where we are, Ms. Johnson, your closing should focus on why is it that the board should issue the license with the capacity of two or four. And Mr. Upright, your argument should be why is it the board should not issue the capacity to two or four, and why the board should issue a capacity of 100. Okay. All right. Go ahead, Ms. Johnson.
Yes. CSW is asking that the board issue the license for what the certificate of occupancy states, 204 people. There has been testimony by the ANC that stated that a tavern was there previously. So they have already, the neighbors, that neighborhood has already become accustomed to actual tavern that operated as a tavern with the capacity to hold the 204 people in the building. CSW has already been holding events. For a while, the ANC wasn't even aware that that events were being held until we stated it during one of our conversations. So there has been no disruptions to the neighborhood, because if it were, they would have known that events were being held. Dr. Jordan testified that one of their largest events, which holds 160 people, has been held twice. And again, the neighbors had no idea that it was even being held, because CSW has been courteous to its neighbors, both commercial and residential. CSW has several things in place to make sure that there are easy methods of egress as required, regardless of whether or not a tavern license exists. In the case of an emergency, they have their staff on hand to make sure that people can enter and exit the building accordingly without any issues. They have what was admitted as Exhibit 6. They have in their contract that states for anyone that rents it, they reserve the right to stop serving them at any time, that they check IDs and all of that. So there really has been and will continue to not be any issues with the license being issued for the capacity of 204 people. Without doing so, it would handicap CSW. Their largest event, they will no longer be able to hold it. They are planning to try and work with Southern diplomats and other organizations to hold similar events over the holidays, to where they will need the capacity of 204. So we are asking that the license still be issued at 204, so that CSW can operate at the full capacity which their building, their certificate of occupancy allows them to do.
Mr. Upright.
So there is a big difference between several one-offs, as I'll put them, or single events, as I'll put them, is perhaps a better way to say it, than operating this as a continuing ongoing enterprise that, as Dr. Jordan has indicated, he would like to do. We are still concerned with that number of people for the same reasons: the negative effect on peace, order, and quiet for the neighborhood, the negative effect on the property values of the neighborhood, and the negative effect on the vehicle and pedestrian traffic. So this is still our overriding concern. They typically stated this is today is the first time we've heard they've actually had an event over 100 people. We were not aware of that either. That had not been disclosed previously. So that's new to us. We had heard that their prior to this, that their capacity had been 65 to 70, I believe, if I remember correctly, in previous discussions. That's why we came up. We decided, we came up with the number of 100. We thought that would give them enough leeway, extra leeway, to hold those events. We have, and beyond that, we have not heard anything more about larger events than that. We still believe, for the sake of the neighborhood and the residents in that neighborhood, that capacity should be limited to 100. Thank you.
Thank you. All right, the record is now closed. The board will issue a decision in this case in 75 days. So let me close the record. Let me close up officially. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 PRO 00004, the consortium, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 25 PRO 00004, the consortium, for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. I will now take a roll call vote on the motion before now that it has been seconded. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice. that ABC Board will recess its proceedings to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you very much for your presentation today. As I stated, the board will issue a decision in 75 days. 75 days, it's, I know that we have exceeded in the sense that this matter has been continued by mutual the request of the parties. But for new licenses, the board has 75 days to issue a decision. So we'll issue the decision within the next 75 days. Thank you very much, and you have a great day. All right.
Thank you all.
All right, then.
Question,
Okay.
so
Who's asking a question?
sorry.
Yes,
So
sir.
does this mean we still need to issue 1-day permits for the interim?
Yes, sir. You have to continue. You have to continue applying for 1-day permits, which the board approved one today, until you have received. The board has issued its license. So I'm not sure. We have 75 days to issue the decision, and so once we've issued the decision, and then we'll issue your license, and then. But you have to continue applying for 1 day until that that has been
And then
you have received that.
Then the license will be good for 1 year from the day that the board approves.
It says 3-year license. It says 3-year license. However, your license will be renewed when all the tavern licenses are renewed, and I'm not sure if this is what cycle we're on. So I'm not sure when the cycle is for. So if off the top of my head, if we just renewed taverns for 3 years, then your license is good for 3 years. If the tavern licenses are up for renewal next year or in September, you have to renew your license when you're on the cycle. So all tavern licenses will be renewed at the same time. So I'm off the top of my head, I can't state where we are in the renewal process for taverns. But it's so if this is the cycle for taverns, then you'll get a 3-year license. If it's not in the renewal for taverns, then you'll get a license for that renewal period. And so when all tavern licenses are up for renewal, then your license will be up for renewal.
I guess I just say request consideration to make sure that we don't have it approved and then within 30 days it has to go through a renewal.
I can't answer that question today, but I know that all licenses, all the classes there are renewed at the same time. All right, so I don't know where we are, but we will see. I will talk to our general counsel and we'll figure out what the process is. Okay.
If I may.
This is just we're having just general conversation since the case is over. Yes, sir.
Could the ANC withdraw their protest if we were to reach a settlement outside during that period of time?
If you
I don't think it'll happen, but we are open to it, certainly.
I mean, the parties can do whatever they they want to do, they can submit something to us if they so desire. And if our legal office doesn't have to write a decision, but I don't know. The parties can do whatever they want to do, and that's up to whether or not if an agreement is submitted to the. Let me say this: if an agreement is submitted to the board, I've always supported settlement agreements because I know that with settlement agreements, the parties have jointly agreed to the conditions they can live to. When the board issues a decision, one side is happy, the other side is unhappy. But as I state, I mean, if the it's up to the parties what they want to do, and but we have had a hearing, and the board will issue a decision. And if the parties decide that they don't want the board to issue a decision and they want to settle this matter, and they submit a settlement agreement, I mean, the board will consider it. Okay.
Thank you.
All right. Thank you very much. Have a great day.
You too.
All right. So we're now at the end of our calendar for the day, and so I'm going to close the record.
With the renewal, you have to pay the
Mr. Jordan, you can please reach out to our licensing division.
No
The
problem.
person you have been contacting, you have had conversations before, and they will provide you that type of guidance. Okay, because I can't answer the question because I'm not in that division. We are the board, we regulate it, but the day-to-day about what you need to pay and how much, I can't answer that question. So please reach out to the licensing division and they will provide you all the information you need, sir. Okay. All right. Have a great day. Okay. All right. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on August 13th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for August 13th, as published in the DC Register on August 8th. Is there a second?
And I second.
Ms. Quinn has seconded the motion. I will take a roll call vote on the motion before that has been properly seconded. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that the ABC Board will hold this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on the electronic calendar on ABCA's website, and published in DC Register in as timely a manner as practical. We're now adjourned for the day. I would like to thank all members of the public who participated in our hearings today, and also our board members who participated in our hearings. We're now adjourned. Thank you very much. I now ask all board members to return to executive session for further action. Thank you.